Thank you, Imran. Sans plus tarder, nous allons commencer avec la première session, donc la session 7, consacrée aux recherches et la documentation sur les réparations. Cette session sera modérée par le professeur Luzolo Bambilesa, que j'invite sous vos applaudissements à me rejoindre ici sur le podium. Le professeur Luzolo Bambilesa est le président du comité scientifique d'experts, comité scientifique sur la justice transitionnelle en RDC. Il est ancien ministre de la justice et des droits humains de la République démocratique du Congo. Donc vous avez 1 heure pour votre session, professeur.
Bien, mesdames et messieurs, bonjour. Je préfère parler ici. On va commencer la journée d'aujourd'hui, mais avant de commencer, j'aimerais remercier le comité organisateur parce que j'ai plusieurs fois été invité moi-même aussi comme expert de l'Union africaine sur la justice transitionnelle à d'autres forums. Je croise quelques visages ici, des amis que j'ai pu croiser ailleurs, et ma reconnaissance, c'est de vous voir aujourd'hui en République démocratique du Congo, et j'en profite pour signaler à l'ensemble de l'assistance le correctif qui a été apporté hier par mon collègue le professeur Moubiala Moutoy, c'est que le contexte de ce 9e forum tombe bien parce qu'on n'y a pas beaucoup insisté, même le ministre n'a pas assez insisté, que vous tombez à point nommé parce que le Congo est à la croisée des chemins sur la justice transitionnelle. Le Congo, on vous l'a dit, a connu des milliers de morts et au moment où je suis en train de vous parler, la guerre est en train de continuer, les gens sont en train de mourir. Une jeune intervenante hier, ma fille, avait dit, est-ce que la justice transitionnelle c'est post-conflit? Est-ce qu'on peut parler de la justice transitionnelle en RDC parce qu'on est en plein conflit? Oui. Il y a plusieurs cycles de violence et donc la justice transitionnelle, la particularité de la République démocratique du Congo, c'est qu'on implémente la justice transitionnelle pendant que la guerre est en train de se poursuivre et que les morts sont en train de se compter. Il est important aussi de rappeler que le gouvernement a confié la tâche à un comité d'experts pour élaborer un programme de politique nationale de justice transitionnelle en RDC. J'ai eu le plaisir de présider les travaux de cette commission et ce comité a produit un rapport qui a repris une approche holistique de la justice transitionnelle. Mais c'est très difficile à implémenter parce qu'on est dans un contexte de guerre où les conflits est appelé à être résolu, soit judiciairement, mais difficilement, et beaucoup de dialogues, de projets de dialogue se profilent à l'horizon. Et donc la justice transitionnelle doit se manifester en République démocratique du Congo comme étant un cadre de concertation pour la sortie des crises parce qu'il y a plusieurs projets de sortie de crise en République démocratique du Congo et donc la justice transitionnelle doit se battre pour s'affirmer comme étant une voie classique de sortie de crise. Par rapport à la documentation, la séance de ce matin, est-ce qu'on peut parler de la justice transitionnelle sans se documenter? En fait, la documentation, nous sommes tous des experts et des chercheurs, est une phase vraiment essentielle. Est une phase essentielle dans la compréhension de l'implémentation de la justice transitionnelle, non seulement en Afrique, mais à travers le monde. Si on ne se documente pas, comment saura-t-on que la justice transitionnelle est un mécanisme important de sortir des crises. Si on ne se documente pas, comment sera-t-on au courant des expériences à travers le monde de plusieurs peuples en matière de justice transitionnelle? Et donc la documentation est très importante. Et nous sommes en Afrique, c'est le Forum africain. Nous avons une conception de justice transitionnelle, c'est vrai, qui est particulière. Moi, j'ai eu l'occasion d'être invité à Djouba, c'était difficile. À 10, j'étais au Forum au Maroc. Mais ce que j'ai vu à Djouba, essentiellement, si ce n'est pas documenté, nous ne ferons pas la justice transitionnelle pour le plaisir des forums de justice transitionnelle, parce que nous réfléchissons sur le préjudice subi par les victimes africaines, par des actes généralement politiques dans nos différents pays. Alors, il est important que nous disposions des instruments de recherche pour le partage d'expériences, par exemple. Mais surtout, pour que la justice transitionnelle en Afrique ne soit pas un vain mot. Pour que la justice transitionnelle en Afrique soit une véritable référence de mode ou de mécanisme de sortie de crise. Alors, par rapport à ce matin, je vais inviter 3 grands experts parce qu'il s'agit de la documentation. Je vais inviter le docteur Justice Mavé Dengue, qui est directeur des programmes au Forum des juges et juristes africains. Je vais aussi inviter le docteur Bajalo, il est là, le docteur Justice. Sous vos applaudissements, j'invite le docteur Justice. Et j'invite aussi le docteur Baba Jalon, ancien secrétaire exécutif de la Commission Vérité et Réconciliation de la Gambie et membre du groupe de référence de l'Union africaine sur la justice transitionnelle. Enfin, j'invite le docteur Ayo Sogurno, qui est chercheur associé de l'Université de York aux USA. Docteur, vous allez mettre comme ça. Voilà. Ça. Moi, je le mets là. Moi, je mets ici. Et donc, nous allons, en 10 minutes, commencer par le docteur Justice. Docteur Justice, vous avez la parole.
Okay. Thank you very much, Chair, for the wonderful words of introduction. So, colleagues, thank you for the opportunity to share with you a few insights on this important topic of reparative justice. I am going to speak very little about documentation, but I'm going to speak a lot more about research. And I would like to share with you 3 critical questions that I think should shape our research going forward. Because research, as the chair has already mentioned, and documentation is very critical if we are going to succeed in this struggle for reparative justice. And my focus, when I was thinking about the critical areas for research, was on reparative justice for slavery and colonialism. But I think some of the questions that I'm going to pose to you also resonate with answering the quest to answer questions on transitional justice in different contexts. Colleagues, I might also ask some very difficult questions. It is not meant to be criticism. It is meant to inspire us to think critically around how we can deal with certain questions going forward, so that our struggle for reparations can actually be successful. So the first question for research that I think colleagues in the academia who are here, but also civil society colleagues and policymakers who are also here should really critically engage with is the role of international law in the pursuit for reparative justice. We do understand from the research that we have done so far, including at Africa Judges and Jurists Forum, that international law has constraints. International law is currently designed in such a way that it largely is inadequate for the pursuit for reparative justice to redress the harm that arose from the transatlantic slavery and colonialism. But there are opportunities. There are opportunities, particularly in the ICJ's advisory jurisdiction. You would recall that the independence of the Southwest Africa, which is Namibia, was largely a result of domestic action by the revolutionary movements, but supported by international action. And international action was inspired by the decisions of the ICJ. Recently, the ICJ handed out an advisory opinion outlining state obligations in respect to climate justice and climate governance. And there are issues that are raised in that decision of the ICJ, which I think we can utilize for our pursuit for reparative justice, particularly the obligation of states to repair damage that has been done to the environment. And you and I know that colonialism in particular resulted in a lot of environmental damage. And the question is, if the ICJ says under international law, states have an obligation to repair damage that has been done to the environment, the question is, would these same states be excused from repairing the damage that they caused to human beings as part of their colonization on the continent? There are opportunities for domestic litigation as well that we need to think about and research on. I'm not quite sure about litigating in domestic courts against foreign states, because foreign states are protected by state sovereignty, the principle of state sovereignty and immunity. But I think there is scope for litigation against corporates, private companies who are present in local jurisdictions, such as banks and insurance companies, provided we are able to build a body of evidence linking these companies to human rights violations during colonialism. And I think there's a lot of work that is going on in South Africa to establish the role of these private corporates in apartheid and how they benefited. But I think we need to do more around that. Then we also need to reflect on the lessons that can be learned from ongoing litigation efforts. Yesterday, colleagues presented about efforts in Kenya by the Mau Mau and the efforts in Namibia. And some of these were successful, but some of these we need to question. In my view, the decision to settle or to reach an out-of-court settlement in Kenya might have also robbed us of an opportunity to test the application of certain legal principles. So as we litigate in domestic courts, we also need to consider and examine and apply our minds on this particular question. When we are invited to settle outside of the court, what impact does that have on the broader struggle for reparative justice? The second last point of reflection that I want to share with you is this very difficult question, which I believe, though, that I'm qualified to ask because of the work that I have been doing to support our African Union on this question. Is the AU fit for purpose? Are there areas that the AU needs to fix in order to become an effective vehicle for this struggle? We need to ask difficult questions, such as to what extent are our leaders, or some of them, adequately sensitized on this subject? Is Africa speaking with one voice on this issue? Even though we have a resolution that has been adopted. But we need to move from policy to action. And in order for us to move from policy to action, we need to do some kind of mapping as civil society scholars and policymakers to see whether, to establish whether our leaders are speaking with one voice on this issue. The other reason why I asked this question on whether Africa is speaking with one voice is I just did a quick search on the volumes of trade that are taking place on the continent. Africa is the richest continent on earth, by the way, but continues to be dependent on the former colonizers for trade and aid. For example, only 15% of Africa's trade during the period 2023 to 2024 is intra-African, while 85% is with external states, predominantly former colonizers. So that should be something we need to reflect on and critically engage with as we test whether the African Union needs to address certain things or not. Lastly, do some of our leaders have the moral legitimacy to pursue reparative justice when some of them are involved in activities and human rights violations that are akin to colonialism? Here, colleagues, and I know these are difficult truths, but we have to confront them if we are sincere about justice. What does transitional justice mean for the people in Western Sahara? What does transitional justice mean for the people in Eastern DRC? And what is the role of some of the members of the African Union in Eastern DRC? What is the role of some of the members of the African Union in Western Sahara? These are difficult questions. I accept, not easy to answer. And like I said at the beginning of my presentation, Chair, this is not to criticize our leaders, but this is to bring to their attention questions which, if we don't reflect on, we are just not going to be able to bring about transitional justice, let alone obtain reparations for slavery and colonialism. Lastly, are there opportunities in geopolitics for the struggle for reparative justice? I think the way we interact as African states in geopolitics is very important. What does it mean when President Trump takes credit for the resolution of conflicts that involve African states? Is he even resolving them? Or is he just doing it for media attention? So we need to ask these questions. Lastly, it is of utmost importance to link our struggle for transitional justice and reparations to the global struggles, including the struggle for climate justice, because there are lessons to be learned there, including the struggle for the freedom of the Palestinian people, including the struggle for the freedom of the people in Western Sahara, the Sahrawi Republic. We need to link these struggles so that we can galvanize international action. And it is on that basis, Chair, that in 2023, I had the privilege and the honor to coordinate a study visit to CARICOM, where a number, I think about 75 African Union ambassadors took part in that study visit, to engage with CARICOM and learn some lessons on how CARICOM has developed its position on reparative justice. And one of the issues that came out, Chair, in that study visit is the struggle for transitional justice, the struggle for reparative justice, of which these two are actually interlinked, because that reparative justice for slavery and colonialism is part of global transition from one era to the other. It is impossible for a country to just be declared independent without addressing the violations that took place, the harm that was caused during the period of occupation. So these two, reparative justice for slavery and colonialism, is a form of transitional justice, just at a different scale. And one of the lessons that we learned in Barbados is we need to approach these struggles from a global perspective, because that's how we build coalitions. In the United Nations, if you combine Africa and you combine the CARICOM and Latin American countries, you get the majority vote in the General Assembly. And yes, I know that the General Assembly is not as powerful as we want it to be, but it can make referrals for advisory opinions at the ICJ. For the ICJ to be able to pronounce itself on this question of whether the activities of Belgium in DRC, Congo, whether the activities of Britain in Zimbabwe, the activities of Germany in Namibia during colonial time, were those activities a violation of international law or not? Because that question, as we speak today, has not been factually answered. It has been argued, but has not been factually answered. And we need a pronunciation by a judicial body on that. But even if we don't get it, this is a political struggle. And we must exert the influence that we have as a continent, including leveraging on the resources that we have, in order to persuade the former colonizers, or rather the colonizers, to negotiate and agree to reparations. But we must fix our house first. We cannot engage to seek reparations when we ourselves are committing the same crimes and the same transgressions, which we want some to repay. And I will end here, Chair, and I do hope sincerely that I have not offended you, or I have not offended some of our leaders here. I am just raising these as questions for reflection, and it is up to you whether to answer them affirmatively or to answer them negatively. But at least let us try to answer them. Thank you.
Merci beaucoup, docteur Justice. Vous avez vraiment raison de vous appeler Justice. Parce que les questions que vous avez soulevées dans votre intervention interpellent toute l'Assemblée, tout le forum dans le secteur de la recherche et de la documentation. Ce sont des questions brûlantes, mais une grande interpellation, docteur Justice. Merci. Nous passons la parole au docteur Baba Jallo.
Thank you very much, Chair. Greetings to all of you. Now, I was a transitional justice practitioner in the Gambia. And so the information I'm going to say here will be linked directly to the Gambian experience in particular, but in general to the transitional justice process. Now, transitional justice in general is a reparatory project. If you're thinking of having a truth-seeking process, you're thinking of how to repair the damage that was done by historical injustices, by human rights violations, etc. So in that sense, it is a reparatory project. For that reason, doing proper research and having proper documentation for any transitional justice process is extremely important. From the very beginning, though, if you want to have a successful reparatory process, a successful transitional justice process, you have to think very carefully as to why the process started in the first place and how best you can make use of the documentation that comes out, the information that comes out, and in particular, how to make sure that the information that comes out of the process actually helps in transforming the civic culture, the situation that caused, made it necessary to have a truth-seeking process, transitional justice process in the first place. So within the Gambian context, we were fortunate to think of all of these things. And so we are also aware, learning from the history of truth-seeking processes, that in many cases, you would have a truth-seeking process, a transitional justice process, a commission that does their research and investigations and documentation, and then hand it over to the government or the establishing authority, and the establishing authority would sit on the information, which means that the information that is produced by the Truth Commission is not used to correct the ills of the society that mandated the Truth Commission in the first place. So we were aware of this fact. We were also aware that a lot of the people in most transitional justice processes are considered audiences to the process as opposed to participants to the process. Now, we were aware of this, and as a result of that, we decided that we had to make sure that the process is conducted not merely as a truth-seeking process, but as a national conversation, so that everyone in the society is given a chance to either be an active participant or a passive participant, one way or the other. So, having considered that it is a national conversation, what that means is that all sectors of the society, every individual in the society needs to be aware of what is going on. And so for that reason, from the beginning of the process, we ensured that the documentation is done in a way and manner that allows every individual, because not every individual in the society could speak English. And so from the statement-taking process, the very beginning of the truth-seeking process, we ensured that people are able to put in their input, to express themselves properly. And as a result, we had a truth-seeking, statement-taking unit within the TRRC with people who spoke different languages. So when you came into the Truth Commission, or when you met a team outside of the Truth Commission premises, you chose what language you wanted to speak in. And when you go into the hearing hall, you also chose what language you want to speak in. So in order to facilitate the communication and documentation, we had an interpretation unit with people speaking different languages that was able to translate whatever was said there in whatever language, so that everyone is able to participate in the conversation. We had a transcription unit that made sure that all the testimony that happened, everything that happened within the commission, was documented and was transcribed and was proofread and eventually was published into books that are still available online, and they are still available in hardcover. In terms of documentation as well, we had a YouTube channel, so that every single hearing of the TRRC in the Gambia is available today on YouTube. So if you want to listen to or watch any of the public hearing sessions, you need to go to online and type TRRC, and then it would pop up. Now, this was a deliberate policy to ensure that the findings of the commission are not kept to the end, which was the practice. The commission would sit and hold hearings and then keep the findings to the end of the process, and sometimes the findings are not said. We did not want to preempt the recommendations of the commission, but we wanted to make sure that every single Gambian and every person who was interested in the hearings, both at home and abroad, knew exactly what the findings of the commission were going to be as the process is unfolding. And that was a ploy to ensure that the government cannot sit back at one day and say, we did not know about this, or we are not aware of that. We made sure that people and the government, including the government, knew exactly what the findings were going to be in the final report as the process was unfolding, so that at the end of the day, it could be used as a tool for reparatory justice, but also a tool to hold perpetrators accountable, and a tool to ensure that any attempt by the government to sit on the information is subverted from the very beginning. So research and documentation for reparations is what drives a truth-seeking process from beginning to end, and it would be very helpful for truth commissions, truth-seeking processes that are up and coming to ensure that research and documentation in particular are done with some of these ideas in mind. Now, the other and last point that I want to make is that the entire process was transparent from beginning to end. So the public hearings were aired on radio, they were aired on social media channels, they were aired on national television, they were aired on international television, so that everyone, everywhere, anywhere in the world could watch what was happening at the TRRC. That was a form of documentation that was driven by transparency to ensure again that accountability and any possible reparatory justice measures were based on evidence that was out there in the public. And in particular, to ensure that the Gambian people who suffered 22 years of dictatorship had a mentality, a civic culture that is now transformed because of the nature of the truths that they had, that they saw on TV, and to empower them to hold their government accountable. So right now, if you go to Gambia, there are lots of protests every time because the people, the civic culture has been transformed as a result of the documentation that we produced and shared with the people, and that, to some extent, empowered a critical mass of Gambians to be able to hold their governments accountable. I'll stop here, and I'll be happy to answer any questions that anyone has. Thank you.
Merci beaucoup, Dr Baba Jallo. La vérité. Il n'y a pas de réparation sans vérité. Il y a une connexion des mécanismes de justice transitionnelle, même si chaque pays peut choisir quel est le pilier implémenté. c'est la leçon que nous retenons de l'expérience gambienne, de la justice transitionnelle, la documentation, mais surtout la transparence, le partage des informations en relation et avec les violations et avec les réparations. Nous allons passer la parole au docteur Ayo Sogourno pour terminer les présentations de notre panel. Docteur, vous avez la parole. Vous êtes sûr avec ce micro-là?
Merci. Bonjour, good morning everyone. I wish I could do all of this in French for language justice. Unfortunately, it's also going to be in English. Research and documentation is not always exactly the most exciting discussion. And so I'm grateful to our organizers for putting this first in the day and not maybe after lunch or something. That would be much more difficult at that point. If at least my students are to be believed. Nobody likes research like that. However, it's something that needs to be done, and I am grateful to our speakers for having, giving some contextualization and framing that I would like to build on in this presentation. So, what I want to do in the brief 10 minutes is to provoke our mind around how we think of research and documentation in the context of reparations. Too often, when we talk of research, when we talk of documentation, we tend to see it as a technical process, something that we carry out as part of the transitional justice process. We collect data, we preserve records, we analyze patterns, all of these things. And then we go into the reparations process. But in reality, research and documentation are also substantive elements of reparations. They're not just a step that we take. The basic principles point out that victims have the right of access to information on violations as well as the reparations mechanisms. So that means that right to documentation should be substantive in itself. It shouldn't just be seen as something preceding the reparations process. But what do we see in reality? There is an information asymmetry between perpetrators and victims and survivors. The people, whether in terms of colonial history or contemporary circumstances, who perpetrate injustices, who perpetrate human rights violations, tend to be more equipped with the knowledge of the context around this. Colonial systems, modern states, military forces, even corporations, they have documents, they have data. Think of all the horror stories we were listening to yesterday. When a woman is seated in her house, when a man is at his farm or place of work, and people come in with guns and start killing, this person doesn't know the context of that violence. They only are aware of their own immediate situation. Yet, the perpetrator planned this. The perpetrator knows what they are targeting. They have that information. So we can't always expect victims to be the ones to piece together, like solving a crossword puzzle or a jigsaw puzzle, all these data around the context of the violations. So what do we need to do? We need to start rethinking how research and documentation are understood in our transitional justice process. We should see it as a form of reparation in itself, not just as something we do before the real reparations begin. And why is that? Because by contextualizing research and documentation as substantive rights in themselves, what we then do is we operationalize the right to truth. We make it more viable, more meaningful. We also create a framework for accountability that transcends usually the immediate political circumstances of the time. Too often we've seen transitional justice processes begin with so much political will, but after a few years, it starts kind of degrading over time. But by actively ensuring that research and documentation continue to be seen as ongoing rights of victims, then the accountability framework can last beyond the immediate political context. And then more importantly, it helps to institutionalize knowledge across the board in a way that ensures non-repetition of these violations. So, what are the practical things I would recommend? And I have 5 ideas here, some of which different organizations and institutions have already started practicing, but I just want to highlight them broadly as things we can all and should all think of as possible pathways for future reconceptualization of research and documentation as rights in themselves. And of course, I need to add a caveat that ideas are easy to have. Implementing them, operationalizing them, is always a difficult part. So forgive if my academic background makes me also look, too theoretical. Like, it doesn't work like that in practice. But it's good to have ideas anyway. Also, of course, it's also important that even though we're talking about reparations today, it's still a pillar of transitional justice as a whole. And some of these points I'm making are also applicable to the broader transitional justice process. The first suggestion or idea here is the need to have a reparations research network. A network of scholars, researchers, institutions, civil society organizations that can come together to build capacity on how to do research, on how to document, to share methodologies, share best practices, and basically help to systematize and concretize this work. I know there are already initiatives like this in place. There is, for example, the Initiative for Transitional Justice in Africa doing some of this work. But we need to think of this more intentionally as something that needs to be done within our context. Following from this is the need to have some kind of open access digital archive for reparations processes. This should include things like testimonies, legal documents, research findings, and the like that everybody can access, especially victims and survivors. And this would help, of course, to ensure the sustained and long-term infrastructural availability of all of these documents. A third thing that is necessary is how we fund research in this area. Who is doing the funding? Are we relying on donors? Are we relying on governments? We need to find a sustainable way of doing research and documentation in a way that is politically independent, politically neutral, and also has, again, that long-term viability. My first suggestion would also be the necessity of promoting initiatives for incorporating reparations research into university curriculum. We need to find or start thinking of how to redesign a lot of universities' curriculum and academic courses to capture these things. It should just be left in the realm of civil society and institutions of governance. It should also actually be as a part of the academic knowledge and learning process. I know, for example, in my own alma mater, original one at the University of Pretoria, we had to do transitional justice courses in some of our master's programs. But it would be good to see this spread beyond just one or two institutions, but become a standardized process. And speaking of standardization, it would also be helpful to adopt, or at least to try and put steps in place to adopt a continental-wide documentation standard for how we capture research and other forms of documentation, not just for how victims submit processes or how they submit their complaints and things like that, but actually for what are the ethical standards for the reparations process, what are the ways in which governments are documenting findings, what are the ways in which these recommendations are being implemented. It would be ideal to have a standard process that governments across all African states can also adopt. So these are some of my brief points. I hope it gives us some opportunity to reflect. The whole point of this is to ensure that we don't see research and documentation in reparations as just this symbolic gesture or technical or procedural step, but as something that is actually important and material to the process of transitional justice. Thank you very much.
Merci beaucoup, Dr Ayo. La documentation et la recherche des réparations, mais surtout la documentation et la recherche des crimes commis dans une période déterminée. Comment implémenter la justice transitionnelle? Souvent, il arrive que la justice transitionnelle commence à être implémenté bien longtemps après la commission des crimes. Comment documenter ces crimes-là? Donc, un réseau de recherche, les archives, une volonté du gouvernement à pouvoir favoriser la documentation. J'insiste beaucoup là-dessus parce que même si cela n'est pas apparu au départ, mais j'ai dit que nous sommes une rencontre d'experts. Qui dit expert dit documentation, qui dit expert dit recherche et partage d'expérience. Merci beaucoup, Dr Ayo. Vous avez entendu, mesdames et messieurs, mes trois intervenants. On va passer la parole à l'Assemblée pour quelques interventions. Signalez-vous et on va enregistrer les questions assez rapidement. Mais encore, j'insiste que c'était un des panels les plus importants parce qu'il interpelle les chercheurs, il interpelle les experts. Je commence par le professeur Moubiala qui va faire circuler le micro. Organisateur, il n'y a pas un micro dans la salle?
Merci beaucoup, monsieur le modérateur, cher estimé collègue professeur Luzolo. Merci beaucoup aux intervenants. Et le modérateur vient de souligner l'importance de la recherche et de la documentation dans ce que nous sommes en train de faire. J'interviens surtout par rapport à à la communication du docteur Mazavengue. En réalité, je ne sais pas si on vous appelle justice, ce n'est pas votre prénom, c'est plutôt comme juge, j'espère. On vous appelle justice en tant que juge ou bien justice comme prénom. I don't know if it is your first name. Alors, donc, si c'est votre prénom, alors c'est une bonne chose. Alors, vous êtes intervenu sur la difficulté d'engager des procédures aussi bien sur le plan national qu'international, contre les abus du passé. Et en grande partie, cette difficulté est due au droit international colonial. Et vous vous rappellerez que le principe qui a été formulé par l'arbitre unique Max Hubert en 1927 dans sa sentence arbitrale en l'affaire de l'île de Palmas, qui dit qu'on doit appliquer le droit qui existait au moment des faits. Alors tout cela a bloqué beaucoup de procédures au niveau international, notamment contre des abus de compagnies internationales des États étrangers, des États dans le cadre de l'esclavage ou de la colonisation. Alors que pensez-vous de l'effort qui devrait être fait sur le plan doctrinal, notamment par les TWL, les Third World Approach to International Law, pour pouvoir remettre en cause et même enrayer, éradiquer ces principes du droit intertemporel de Max Hubert, en fait, qui est devenu en fait un principe appliqué par toutes les juridictions occidentales et même qui s'est imposé sur le plan du droit international. Je vous remercie.
Merci, professeur Moubiala, chers collègues. Docteur Justice, ok? C'est bon. Une deuxième question, madame.
Oui, bonjour tout le monde. Là, ce n'est pas une question, mais une petite réaction.
S'il vous plaît, veuillez vous présenter d'abord.
Oui, là,
merci.
Voilà, Maroc. Voilà, parce que j'ai été sidérée. Pardon, madame. Vous voulez que je me lève? Ah, ok, d'accord. Sans problème. Voilà. Alors, Latif Babdi du Maroc, anciennement membre de la commission de justice transitionnelle, la commission vérité du Maroc. Alors, j'ai été fortement sidérée par certaines aberrations et divagations qui ont été prononcées ici, qui sont, à mon sens, indignes de ceux qui se présentent comme des experts et des chercheurs, et qui reflètent une ignorance complète de l'histoire de la région dont elle a essayé donc de parler, mais aussi pas seulement d'une ignorance historique, mais d'une ambiguïté par rapport au concept sur lequel il s'est basé et qu'il a utilisé, qui dénote d'une ignorance des éléments constitutifs de ce qu'on pourrait appeler colonisation. Parler du Maroc comme pays colonisateur, c'est vraiment une aberration. Et je vous rappelle, monsieur Justice, j'aurais souhaité que votre nom reflète votre position, que le parachèvement de l'unité nationale du Maroc a été le fruit d'un long combat du peuple marocain, qui n'a pas commencé dans les années 70. En 1958, l'armée de libération nationale marocaine, constituée de citoyens de toutes les régions du Maroc, y compris des régions sahariennes du Sud, avait libéré complètement, totalement, les régions sud-sahariennes du Maroc. Et c'est à cause, je dirais plutôt, de la solidarité des colonisateurs que l'Espagne a pu récupérer le Wadi Dahab, les régions, les provinces sahariennes du Sud. C'est les bombardements de l'aviation française qui a sauvé l'Espagne, qui lui a permis de récupérer les provinces du Sud marocaines. Et le Maroc n'a jamais arrêté de réclamer la libération de ces territoires, l'ensemble de ces territoires, du Sud et du Nord. Le Maroc a été morcelé par les colons et les puissances coloniales. Les Espagnols, les Français, Tanger, qui était une ville internationale où il y avait les Anglais, les Allemands, les Hollandais, tout le monde. Alors, au lieu de se soutenir les uns les autres ou d'appuyer notre combat pour la libération de tous nos territoires et la préservation de l'unité territoriale de nos pays et l'unité de nos peuples dans toute l'Afrique, on se crée des problèmes les uns les autres. On le voit ici, on l'a entendu. Ça a été dit hier par les responsables du Congo démocratique, de la République du Congo démocratique, qui vivent des situations un peu similaires. Au lieu de se soutenir, de se souder les coudes, on se crée des problèmes et on se met des bâtons dans les roues pour empêcher le développement et l'épanouissement des pays voisins. Malheureusement, c'est ça la situation. Monsieur Justice, je vous rappelle que moi, qui étais dans la commission vérité marocaine, que la justice transitionnelle a bien eu lieu dans les provinces sahariennes, comme ça a été le cas dans toutes les régions du Maroc. Nous avons travaillé sur l'ensemble du territoire. 66 détenus du Polisario qui étaient armés, qui étaient dans les conflits, ils ont été remis en 91 à la Croix-Rouge internationale. 144 qui étaient morts pendant les combats ont été enterrés dans tout le respect des rituels religieux. Le reste, près de 400 victimes ont bénéficié du programme de la vérité sur lequel je travaille personnellement dans la région. J'ai travaillé sur l'établissement de la vérité, le sort des disparus dans la région, moi-même. Et nous avons travaillé sur la réparation. Plus de 400 victimes ont bénéficié des réparations. Des réparations allant de l'indemnisation à la couverture médicale, à l'insertion sociale, au logement, à toutes sortes, dont ont bénéficié toutes les victimes dans les régions du Maroc. Le Sud marocain a bénéficié du processus de justice transitionnelle comme l'ensemble des régions du Maroc. Il n'y a pas eu exception. Ce sont nos citoyens. Ceux qui ont été victimes de violations, d'exactions des droits de l'homme graves, comme dans toutes les autres régions, et des fois moins que d'autres régions, ont été bénéficiaires et partie prenante, parce qu'ils ont contribué dans la réussite et l'implémentation du processus, comme dans l'ensemble du pays. Et la justice transitionnelle a été pour une justice transitionnelle pour tous les Marocains et les Marocaines sans exception. Et nous avons même, à la fin de nos travaux, considéré que nos citoyens qui ont été victimes de violations du Polisario, qui ont été dans les geôles des séparatistes, comme la prison Rachid, etc., qui ont été victimes de tortures et de déplacements forcés, nous les avons indemnisés. Nous les avons indemnisés, même s'ils n'étaient pas des victimes des exactions commises par les appareils de l'État marocain, mais nous avons considéré que ce sont des citoyens marocains qui ont été victimes de violations commises par des partis en conflit avec le pays. Nous les avons intégrés dans le programme de justice transitionnelle. Ils ont bénéficié au même titre que les autres des différents programmes de réparation. Et merci pour votre attention.
Bien, s'il vous plaît. Nous sommes en train d'échanger amicalement en tant qu'experts. Nous sommes en matière de recherche et de documentation. S'il y a une divergence de compréhension, nous allons l'assumer, mais en toute aisance et en toute respectabilité. j'espère que les prochaines interventions ne seront pas tout aussi chaudes que celles-là. Vous avez la parole, madame.
Oui.
Ici. Non, j'ai accordé la parole ici. Oui. Donc la question, jusque-là, on a noté 2 questions au docteur Justice. Précisez bien à qui vous adressez, veuillez préciser à qui vous adressez la question. Madame, vous avez la parole. Ici. Oui. Oui, oui, vous. Oui.
Oui, merci beaucoup, professeur, pour m'avoir accordé la parole.
Je ne vous ai pas accordé la parole, j'ai accordé la parole à madame. Vous n'êtes pas madame.
J'avais déjà le micro, professeur.
Pardon?
J'avais déjà le micro, désolé.
Non, vous n'êtes pas madame, s'il vous plaît.
S'il vous plaît.
Thank you. I'm not too sure I can promise on your suggestion that I try to tone it down. Mine is a comment really about how we project ourselves as experts. And this is a very important thing because often transitional justice is criticized for being a legal dominated process. And by the way, I'm a doctor. I'm a doctor of social science. I got an honorary doctorate, and I'm also a victim, and I'm an expert. So when we talk about documentation, and from the perspective of jurists and legal fraternity, I think it's very important for victims to understand what evidence they have to produce in order that they are recognized as victims. So this is the most important, actually, network, because it's very re-traumatizing to have to relive and provide evidence of loss and torture and everything else. So I just want us to correct our language and also be humble in how we invest our expertise and our knowledge, because everyone in the room is an expert, and particularly people who have got direct experience. So it's my comment, and also I think when we talk about in a network, let's also consider what a type of network that victims need to have across the continent, and to share their experiences as well. Thank you.
Merci beaucoup, madame. Maintenant, cher ami derrière, le monsieur, vous avez la parole.
Merci, monsieur le modérateur, pour m'avoir accordé la parole. Je réponds au nom de Maître William Wenga. Je suis de la Coalition congolaise pour la justice transitionnelle, qui est une plateforme des organisations de la société civile qui milite sur la justice transitionnelle. J'ai une petite préoccupation. Je commence d'abord par le docteur Justice, parce qu'il a beaucoup parlé de la justice réparatrice. Je me suis posé des petites questions par rapport à son intervention. J'ouvre d'abord une parenthèse. Docteur Justice, nous qui sommes venus de l'Est du pays, nous avons été saisis par les victimes de Mwenga. Pour votre information, Mwenga, c'est le territoire où les femmes ont été enterrées vivantes. J'espère que la plupart d'entre vous connaissent ce qui s'était passé, les massacres de Mwenga, dans la province du Sud Kivu. Les femmes ont été enterrées vivantes avec des enfants. Nous sommes en République démocratique du Congo. Des femmes et des enfants ont été pillés comme des maniocs ici en République démocratique du Congo. Je me pose la question, monsieur docteur Justice, nous en tant qu'organisation de la société civile qui milite sur la justice transitionnelle,
qu'est-ce que nous pouvons dire à toutes ces femmes, des enfants, les victimes qui sont restées, pour dire que non, il y a une justice réparatrice. Et ces victimes, est-ce qu'ils vont encore vous croire? Nous sommes encore ici en République démocratique du Congo. Nous avions connu un ministre des droits humains qui est allé s'agenouiller devant les victimes au Kasaï. Ce sont des preuves palpables. Le ministre est allé s'agenouiller pour demander pardon aux victimes. Mais depuis hier, nous sommes en train de suivre toujours des acquisitions de réparations pour payer, pour acheter ceci, mais il y a des victimes qui ne demandent pas tout ça. Hier, j'ai reçu un appel d'une dame qui est à Sake. Vous connaissez Sake, c'est dans la province du Nord Kivu, actuellement occupée par les M23. Elle m'a posé la question, maître, vous êtes à Kinshasa. Nous avons appris qu'il y a un forum national sur la justice transitionnelle à Kinshasa. Plusieurs pays seront sur place. Nous, en tant que victimes, nous n'avons pas besoin de vos millions. Nous n'avons pas besoin de vos milliards. Moi, tel que je suis ici, je suis victime. Les militaires sont arrivés chez moi. Ils ont tué d'abord mon mari. Ils ont tué mes 4 enfants. Et après, ils ont coupé les parties génitales de mon mari et m'ont exigé de manger ça. Dans ces pays, là, nous sommes devant des crimes imprescriptibles. Je pense que le professeur Luzolo, il nous répète toujours des crimes imprescriptibles que nous sommes en train de vivre en République démocratique du Congo. Pour docteur justice, devant cette situation, et je ne vais pas entrer dans d'autres, parce que nous avons des cas de Kisangani, nous avons des cas du Kasaï, nous avons des cas d'un peu partout à travers les pays. Devant cette situation, vous, en tant que docteur, vous nous parlez de réparation, justice réparatrice. Comment, nous, acteurs de société civile qui sommes sur terrain, pouvons-nous nous appliquer pour qu'on puisse quand même soulager ces femmes, ces enfants qui ont vu leur père tué en train de souffrir? Ça, c'était ma première occupation. La deuxième préoccupation, je voulais poser une petite question au docteur Aouros, qui a parlé de comment mettre en place de manière pratique un réseau de documentation et de recherche. Est-ce que vraiment, docteur, vous pouvez nous donner d'une manière pratique comment le réseau pourra fonctionner pour que nous aussi, en tant que pays membres de l'Union européenne en République démocratique du Congo, nous puissions en profiter aussi et nous retrouver dans ce réseau, j'ai dit.
Bien, merci. Docteur Ayo, vous avez entendu la question? On va prendre une dernière question. Oui. Ah, je vois qu'il y a... Mais si vous écoutez la présentation de vos questions, nous allons maximiser les questions. Mais si vous prenez la parole pour reprendre la conférence, c'est difficile. Vous avez la parole, cher ami. Veuillez vous présenter et faites votre intervention.
Monsieur Bernard Balabala Mbouadi, directeur de protection des droits humains au ministère des droits humains. Ma question s'adresse au docteur Aoyo sur la recherche et la documentation. Quels sont les obstacles majeurs à la collecte des données sur les violations commises lors de la traite négrière, de la colonisation et des récentes exactions dans les conflits en Afrique et particulièrement en RDC, surtout dans l'identification des violeurs et des victimes, étant donné que dans la plupart des cas, il y a la négation des États violeurs ainsi que de groupes armés. La deuxième question s'adresse au modérateur, mon ancien ministre de la Justice et droits humains, le professeur Luzolo Bambi. Avez-vous jamais réfléchi à l'intégration au programme académique dans nos universités de la matière de la documentation en recherche en justice transitionnelle. Je vous remercie.
Merci. On va s'arrêter là. L'organisation nous rappelle à l'ordre par rapport à la tenue du temps. C'est un peu délicat et particulier qu'on pose une question au modérateur. Je vais accorder la parole à mes 3 intervenants assez rapidement pour qu'on termine le panel. Docteur Justice, on commence par vous. Vous avez la parole.
Thank you very much, Chair. And I think I have 3 questions. I will try to answer those 3 questions as briefly as I can and as politely as I can. The first question was, Justice is my name, but thank you for the compliment. Then you asked the question about colonial law and how do we deal with the fact that the argument that is often used in response to the demand for reparations for slavery and colonialism is always that at the time that colonialism and slavery was conducted, those activities were lawful. Well, that is the controversy. That is the question that needs to be interrogated. And that's why at the beginning of my presentation, I said it is necessary to seek a judicial pronunciation or a judicial declaration on that particular question. But the analysis, with due respect, I've written some analysis on that, which is out there, on what the position of international law is in respect to colonialism and slavery. And others have also written on that subject. And it is my humble opinion that international law at the time of slavery existed. And there is something that was called principles of customary international law, which basically recognized that human beings are born with dignity. And therefore, they are to be treated in a dignified manner. There does not seem to be any justifiable reason for treating everyone with dignity except the African. Because that's what slavery and colonialism did. It respected the dignity of everyone except the African. There doesn't seem to be a justifiable reason for that. And I believe that that can be challenged, particularly before a tribunal like the ICJ, although it doesn't have the jurisdiction to issue a binding decision, but it can issue an advisory decision on this particular question. And I do believe that slavery and colonialism was illegal. Another thing that strengthens my argument is the recent decision of the ICJ on climate justice. It underscores the point that since time immemorial, there has always been the duty to remedy or the duty to repair damage that is done, particularly on human rights violations. And it says, since time immemorial. Then the other point that I wanted to mention, which supports that particular position I'm advancing, is the first United Nations Declaration on Decolonization, which was adopted in the 1960s. It says the United Nations reaffirms its recognition that human dignity of everyone is to be respected. It didn't say from now onwards, 1960, we are now, as an international community of nations, recognizing that everyone has human dignity. It says we are recommitting ourselves, which means this commitment was there before. So on that basis, I think we have a strong argument when we say slavery and colonialism were illegal. The second question that was raised concerns my remarks about Western Sahara, the Sahrawi Republic. There are two judgments that I would like to draw our attention to. The judgment of 16 October 1975 of the ICJ, which basically said the occupation of Morocco, the occupation of Western Sahara by Morocco, is illegal under international law. Because prior to the colonization of that territory by Spain, the socio-political and economic ties between Morocco and the tribes in Western Sahara were not sufficient enough to then justify the placement of Western Sahara under Morocco as part of decolonization of that particular territory. This is a judgment of the ICJ. Then recently in 2021, the Court of Justice of the European Union was petitioned, whereby an agreement between Morocco and the European Union, which accorded the European Union the rights to fish and exploit resources from the sea that is on Western Sahara. That agreement was challenged before the Court of Justice of the European Union. And the Court of Justice of the European Union issued a binding decision which underscores the position of the ICJ. So I am speaking from the position of what is factually there. I'm not giving my own opinion. Then number 3, will the victims in DRC believe that reparations exist? So, I'm answering the third question. Yeah.
Madame, je vous en prie, s'il vous plaît. S'il vous plaît. S'il vous plaît. S'il vous plaît. Bon, on retire, on suspend cette question. On suspend la question. Oui, oui. On suspend la question du Sahara occidental. S'il vous plaît, madame. On retire, on suspend ça. Je demande, s'il vous plaît, je demande à l'assistance de bien vouloir ne pas considérer cet incident. Je vais passer la parole au docteur. On a entendu votre position. S'il vous plaît. Merci. J'accorde la parole au docteur Ayo.
Merci. This is all part of the process. So I think the questions that were addressed to me, I would just answer very briefly. The one around the network. Of course, the idea here is to have an actual exchange of knowledge, an actual exchange of capacity and understanding. And as was pointed out, it also should include victim communities as well. So it's not just scholars, it's not just university or civil society experts talking. It's also about victims as well, also having and developing capacity for engaging with different mechanisms across the board. So in terms of operationalizing, it's not something we can go into in full details now, but the essential aspect is that some organizations have already begun work like this, like I mentioned. The idea Thank you. The idea is for this initiatives to be supported by institutions like the African Union, like various domestic governments, and making sure that they be going to have the capacity and the size or the tools needed to include more resources, to include more communities, to include more institutions, universities, and individuals. Regarding the question around that was the challenges and obstacles in data collection, I think I want to emphasize that, again, when it comes to transitional justice, it's not like law of contracts. It's not like two people disputing over a business deal gone bad. You come with your own evidence, I come with my own evidence, and let the judge resolve it. We're talking about human rights violations. And I believe firmly that you shouldn't put the burden on the victims, on survivors, to be the ones trying to show that these violations have occurred. And it's the more reason why those who have the means, the capacity, and I'm talking of institutions, I'm talking of governments, should be heavily involved in creating and putting together the evidence necessary for these incidences to be dealt with properly. So it's about centering victims without burdening victims in the process. So, of course, challenges would differ from context to context. What would be the evidentiary requirements in a situation that is colonial in nature or historical colonial, 20, 40, 50 years ago, will be different from something that is happening right now in the moment when information is changing rapidly and the like. So, but the important thing for me is, again, to remove that burden and to ensure that there are actual significant investments in building the body of knowledge necessary for commissions, for institutions and other bodies to be able to do the work of reparations. Thank you.
Well, I haven't had any questions from the audience, but I would just say that countries that are planning on carrying out transitional justice processes or that are working on them should make sure that their communication, research, and documentation processes are, one, very inclusive of the entire nation, the entire population, and two, transparent. The lack of transparency is what perpetrators use and governments use to sit on information and documentation that is supposed to be the healing medication, if you like, for a society that has gone through a lot of trauma. So research and documentation in an inclusive and transparent manner is one thing that truth-seeking processes and transitional justice processes in general should take very careful note of. Thank you.
Merci. J'avais dit qu'en principe, le modérateur ne reçoit pas de questions. Mais pour clore, j'aimerais quand même répondre aux messieurs par rapport à l'organisation de la recherche sur la justice transitionnelle. Moi-même, j'enseigne en 3e cycle à l'université de Kinshasa, au département de droit privé, au département de droit pénal et au département de droit de l'homme. Depuis 3 ans, le thème que j'exploite en 3e cycle, c'est la justice transitionnelle. Mais je lis aussi dans les réseaux, il y a d'autres universités, particulièrement les universités européennes, qui organisent des enseignements sur la justice transitionnelle. Si c'est une recommandation pour l'Union africaine d'obtenir des États qu'ils implémentent les cours de justice transitionnelle à travers les universités, c'est pas mal. J'aimerais clôturer en disons ceci. Ce panel a porté sur la recherche et la documentation. Et je me rappelle avec beaucoup de plaisir le dernier forum auquel je pris part à Rabat, au Maroc. Et au cours de ces débats, nous avons eu parfois des moments un peu difficiles d'échange comme ça au Maroc. Et ces moments difficiles revient un peu à Kinshasa, c'est dommage, mais ne nous attardons pas à cet aspect particulier. Lorsque les experts se rencontrent, il y a souvent des divergences de vues, mais le plus important, c'est de montrer que la recherche et la documentation au sujet des crimes passés ou présents devaient amener à la promotion de la justice transitionnelle, parce que la justice transitionnelle, c'est le message quand je regarde dans la salle, l'âge, quand je regarde l'âge croisé de nous tous qui sommes dans la salle, hier j'ai entendu les jeunes parler et se déclarer comme étant des véritables victimes des différentes atrocités, des victimes de l'Union africaine, les jeunes, les femmes, les enfants. C'est la justice transitionnelle que nous allons léguer à l'Afrique de demain. Parce que chaque peuple, chaque circonstance a droit à la justice. La justice transitionnelle, c'est l'avenir de l'Afrique. C'est même le présent et l'avenir de l'Afrique, parce que c'est la réponse ultime aujourd'hui que l'Afrique peut donner à la jeunesse. Et donc pour cette jeunesse-là, pour qu'elle s'en prémunisse, il faut qu'elle ait recours au réseau de communication et à la documentation pour qu'elle connaisse ses droits, qu'elle apprécie les violations qu'elle a subies et qu'elle puisse collectivement réclamer la justice. Parce que là, finalement, la justice en Afrique d'aujourd'hui et de demain, ce n'est plus la justice classique, c'est la justice transitionnelle. Je vous remercie.
Merci beaucoup, professeur Luzolo Bambilesa, que je vous demande d'applaudir, ainsi que le panéliste. Nous allons continuer notre programme avec la section 8 portant sur le mécanisme judiciaire africain pour les réparations et la guérison. Pour cette session, je vais inviter M. Christmas Tafadjoa, coordonnateur de programme de l'initiative pour la justice transitionnelle en Afrique. Tafadjoa, over to you. Donc, il va introduire les différents panélistes pour cette session. Vous avez 1 heure aussi pour la session.
Thank you so much, Prof. Bakama, for the introduction. My name is Tafazo Christmas. I work for the International Center for Transitional Justice. I serve in the capacity of program coordinator for the Initiative for Transitional Justice in Africa, which is a continental project that was jointly launched by the AU and the EU that is an overall objective of promoting the popularization of the African Union Transitional Justice Policy, as well as ensuring its domestication across the AU member states. For this particular session, I've been told that we have strictly 1 hour, so I'm not going to waste any more time. We are going to discuss the African justice mechanisms and their contributions to reparations and healing. And to help me conduct these discussions, I have a panel of 4 experts, which is evenly balanced. We have 2 women and 2 gentlemen. So I will just call out our panelists to come, and they can share the stage with me, and then we can start the discussions. I call upon Ms. Ayemi Ongeso, the program manager of Open Society Foundation, to please come forward. I also kindly ask Mr. Patrick Hajayandi, the senior project leader for the Great Lakes region of Africa under the Institute for Justice and Reconciliation, to please also join me on the stage. And if Mr. John Coker, the executive director at Fambo Tuk International from Sierra Leone, if you can also kindly join us, as well as Miss Nesma Sehandri from Libya to also come and join us. We are still missing some people. I think they come. Oh, from the AU, sorry. Yes, I think our panel is almost complete. Thank you, Joe. So, before we start the panel discussions, I just thought maybe it would be important for us to frame the discussions we are going to have with the panelists. So I'll start by, first of all, just recounting the journey we have traveled in terms of recognition of African justice mechanisms. In the early writings of anthropologists, when they came and encountered African indigenous communities, they concluded that most of these African communities were acephalous, which literally means that they were without heads. And without heads, by that they meant that there was no hierarchical structure. It meant that there was no hierarchical structure within those communities. So in their writings, they concluded that because there was no hierarchical structure, there was no governance, and therefore there was no law. This is what the early anthropologists came up with. But as they looked closer in these communities, they realized and they came across such African justice mechanisms as we all know, like Gachacha, Matoput, the Magamba spiritual mediums in Mozambique, Fambo Tuk in Sierra Leone, which we are going to talk about. And then they started to recognize that there are actually mechanisms within African societies that are aimed at resolving conflicts, that are able that are responsible for actually meting out the law. But then we still had a challenge, because even at that particular stage, the approach was that of problem solving. African justice mechanisms remained in the fringes of what was determined as real justice. They were problematized, and in most cases, they were stigmatized as kangaroo courts that require a technical fix. So you find that scholars like Deborah Issa highlights that African justice mechanisms were defined in comparison with formal justice mechanisms, and were seen as a sort of subspecialty, a side issue, a problem that needed to be fixed. So you find, if you look at the literature, in the early literature, you find a lot of writings that look at the Gachacha and look at how it falls afoul of human rights standards, how it misses so many marks in terms of it in comparison with the formal justice mechanisms. But I'm happy to announce that we have moved away from those early positions, and we have come into an age where we have the African Union Transitional Justice Policy. And within the African Union Transitional Justice Policy, one of the cardinal principles that is enunciated in that policy is that to do with national ownership, national and local ownership. And among the elements that form national and local ownership is the need for us to make use of the formal and traditional, judicial and non-judicial resources that we have in our communities as part of the measures that are aimed at providing justice and reconciliation within the TJ processes. In actual fact, the African Union Transitional Justice Policy now recognizes African traditional justice mechanisms as a key indicative element of transitional justice. That being said, I'm sure the panelists that join me here are not here to romanticize the African justice mechanisms. They are aware of the shortcomings that these mechanisms have, but they are also aware that there's a lot of untapped potential that we can actually derive from these mechanisms that can not only benefit communities that use the customary law or these mechanisms, but that can also educate the experts that are in this room in terms of what kind of values we can derive from these African justice mechanisms to conceptualize justice, to conceptualize reparations, to conceptualize healing. And in line with that, I've posed a set of questions to these panelists. So in their presentations, they are going to contend with these questions as they discuss their relevant topics. Some of the questions I have for them are quite simple. The first one is, what are we calling transitional justice mechanisms? How do they function? What outcome can they achieve? What challenges arise in their function and implementation? And what contributions can they make towards providing reparation and healing to victims? And lastly, how can they be integrated into our so-called formal or mainstream transitional justice processes? With that, I will hand over to Mr. Patrick Ajahindi, who's going to take us through the African transitional justice mechanisms in the Great Lakes region. Soon after him, I will not come in, I will just hand over to Amy, who's going to talk about alternative justice systems in Kenya. And then we'll move on to John Kauka, who's going to talk about Fumble Tuk and reparations in Sierra Leone. And then we will finish with Nesma, who's going to talk about the traditional healing rituals in North Africa. Thank you so much. You can start, Patrick.
Thank you so much, Mr. Chair. As you said, we are not here to romanticize the African traditional justice mechanisms, but in my discussion, I would like to highlight some of the important points that we should take into account, because during the colonial time, there was a tendency to ignore the importance of these traditional justice mechanisms. But now we are acknowledging the importance of these institutions and these mechanisms, and how through another angle they can contribute significantly to the process of transitional justice. I would like to start by saying that African traditional mechanisms for justice are deeply rooted in the continent's diverse cultural and communal practice. So what they offer is a different approach compared to what we can call the formal justice systems that we have in different countries. So the most important thing is that there is a particular approach that this mechanism offer, which bring really a difference and put them to a position where today we need to be very considerate. I would like to start by telling you that in 2016, I had an opportunity to be part of a team which was conducting a research project on the perceptions of the African population of these traditional justice mechanism. And I was working with my colleagues from Zimbabwe and from Mozambique, and I worked on the Burundi case, where I tried to see the place and the role of the institution known as Abashinganhahe. In Kirundi, it means it's a group of wise people who are tasked with the job of mediating, resolving conflict. So when I did this research, one of the findings was that particularly in rural areas, almost 85% of the population rely on this type of justice mechanism. Why? Because there are some key features which make them an institution to go to whenever these people need justice. So I am going to briefly discuss some of this interesting aspect or characteristic of the judicial system which make them the institution or the mechanism to go to. The first one is that they are community-centered. By this, I mean that whenever there is a proceeding, it's the elders, community leaders, and members of the communities who are leading the process. But beyond that, there are open spaces where every member of the community has a say on any matters, on any dispute, and can propose a solution. Secondly is that this kind of justice system, they push for restorative justice. And I think this is very important when we are thinking about how to promote transitional justice. So the goal for this institution is to restore the relationship within the community and not focus on punishing anyone who has done wrongdoing. So this can include reconciliation, compensation, and also a symbolic act like sharing beer, sharing a meal, etc. But at the center is the need to restore the relationship with the community so that harmony can be also restored. The third element, which is very important, is that they are accessible. The traditional justice mechanisms are often more accessible to rural and marginalized populations due to their informal nature and the use of local languages. So when proceedings are taking place, people can relate to what is happening. The language is clear, is understandable to them, and they know what is happening. So, and lastly, it's an element of flexibility. These, as you know, these traditional mechanisms rely on customary law, which has the possibility of being flexible and to adapt over the time. So these are norms which have been passed over from one generation to the other, but according to the time you are in, you are able to adapt to the context. So those are the key elements which makes this particular traditional justice system very important to be considered. So it does not mean that they are perfect. There are flaws, especially when you look at how masculinity tends to dominate within them, but this is not something which can push us to put them aside. And as Mr. Chair said, it is very important that today these traditional justice systems are considered even within the African Union transitional justice policy. And this has highlighted the importance that even at the national level we should be considering. If I give you an example, in the case of Burundi, this traditional mechanism are now recognized as part of a justice system. So if there is a case within the community which has not been brought to the wise people, you cannot take to the other level. They will ask you first if you have checked with the wise men and see what kind of decision they have made, if you can go further. So if they are able to solve the problem, they will solve it at that level. So it is now ingrained, and there is a decree, there is a law which is in place which acknowledge the important place of this mechanism. The last point I would like to mention, because I wanted to discuss some of the examples, but our chair has already discussed some of the key elements, including the Gacaca Court in Rwanda, the Mato Oput in Uganda, which is focused on forgiveness and reconciliation, the role of the Bashinganhas I mentioned, which work mostly as mediators, and there is another system called the Kotla in Botswana. They also work both as mediators but also as a space for healing. One of the things I wanted to say is how now this element, do they contribute to the healing process? Because this is one of the elements we have to focus on. The most important is that when you consider all over Africa, there is a common features, is that these traditional justice mechanisms, they create a safe space where everyone can come and express himself. And as you know, some of the people, by listening or by having the opportunity to speak up, the burden of the trauma they went through start feeling easy. So I can give you just one example that I think in 2012, we organized an event where we invited one of the lady in Burundi who had been obliged to marry a man who killed her husband. So in a space of 30 years, she told us that it was the first time that an organization gave her a space where she can express herself and say and share the trauma she went through. So, which means this space where people can express themselves, where they can be heard, it's very important. And this is one of the key elements that the traditional justice mechanism offer. So I will close by here, and for the rest I will try to respond to the question. Thank you so much.
Thank you so much, Patrick, for staying within time. I think this was a very worthwhile presentation to set the tone for the presentation that are going to come. I want to recap now, but just to highlight some of the key features of African justice mechanisms that Patrick highlighted. They are community-centered, they are participatory, they are restorative, they are flexible, and he also highlighted that there might be challenges in terms of gender sensitivity, which are some of the flaws that arise from this. But most importantly, he also highlighted that these African justice mechanisms have a cathartic effect in terms of allowing citizens or victims an opportunity to speak and narrate their story. And now we are proceeding and moving on to Ayemi. I hope I'm pronouncing your name well. You have to correct me when you get the opportunity. She will take us through the alternative justice system in Kenya. As you go over to that, I just wanted to share with you a remark made by an author called Paul Greedy, who coined a term called distant justice. And he says distant justice is the justice that lacks domestic participation, that undermines existing norms and institutions, and is often alien to the society at large. Can you comment on that as you go into your presentation?
I'll comment on that as I conclude my presentation, but let me just go straight into my presentation. So my intervention will be narrow and very specific to the Kenyan context. And this is my lived experience, being at the heart of trying to design an alternative justice mechanisms. And so I'll also share some of my practical experience from the front lines. So Kenya experienced post-election violence after the 2007 presidential elections. So most of the efforts that were there at that time for seeking justice for victims focused on the criminal justice system. So for example, at national level, we had 3 major attempts to set up a local tribunal that failed. And then we had the ICC cases, and the ICC cases collapsed. And then we also had, through the ICC process was, the victim participation, which was highly, highly inadequate. And that's a discussion for another day. And then there was a discussion of establishing the International Organized Crimes Division of the High Court, which we were, about in civil society at the time, we were not too supportive of it because the mandate was too wide. And also during this time, the Director of Public Prosecution received 5,000 files of violations that had happened during the post-election violence. He looked at it with a multi-agency task force, and this is what he said. The sad and bitter truth is, at the present, there are no cases arising from the 2007-2008 post-election violence that can be prosecuted. 5,000 cases, none can be prosecuted, and all these people are claiming injustices happened to them. So what do we do with this? In addition to that, we had a skewed IDP compensation for victims. Some victims were receiving just $100 to be able to relocate, we don't know where. And some were also getting USD $400. It was skewed, it was favored, there was discrimination. And one of the senators at the time adequately described this situation as saying, to abandon the victims and give them a token of $100 is a terrible abuse to humanity. Justice at this time appeared very elusive. So what do you do with people who are seeking justice? In addition, whatever was being offered through the formal justice system, which is a long, daunting, and expensive process, was too narrow an offering. Justice meant many things to the survivors that we could not capture through the formal justice system. And the court process and the formal justice system does not have the language or the means to interpret this the expansive meaning of justice. I will give 2 examples. In one of our community consultations, there was a victim, a survivor who had been violated during the post-election violence, and she got a child out of this sexual violation. And she asked, if I take my perpetrator to court, how is that going to help me? Because I have this child and I want this child to be raised. Can you go talk with the family of this man to help me raise this child? So that's a very sensitive example, but it's a reality of what we were receiving when we were interacting with the communities. The second is a lady from a town that we visited. Her brother had been murdered by a family known to them. So she came and told us, we have sorted the issue. How have you sorted the issue? This community went to that community and we discussed and we used our traditional mechanisms, and now our family is okay because the other community is going to take care of the widow and the children. I am just sharing my reflections and what we were hearing from the ground. So for me, I mean, you know, obviously, these are high-level criminal cases, and of course, it should go through the formal justice system. But there's a lot to unpack from these examples. But if we look at it critically, first is the inadequacy of formal systems to address the immediate needs of victims. Second, there was the issue of collective and communal responsibility for a crime that has been committed. So this is often at the heart of traditional African mechanisms. So at this point, when we were in the community, and we were wondering what to do. ICC cases collapsed, nothing is happening at national level, 5,000 cases, there's no evidence, nothing can be prosecuted, it looks grim. So one community member, I will quote him because I was writing this. He said, we want to live in peace, get our properties back and coexist with our neighbors. The people who took our things, we know them. Why should we take them to court? It will make it very hard to live with them again. Also, court processes take too long and are expensive. None of us here can afford a lawyer. Why don't we use our traditional methods to solve these conflicts? As you can see, the ICC is not working. The government of Kenya is not interested in us. We have tried everything. Nothing seems to work. We should go where we can see some justice. And so at this point we said, okay, fine. Let us try and use our traditional ways of solving the conflict. But one, we need to have legitimacy from the community espousing cultural values as Africans. And second, we need legitimacy from the existing legal framework. And so that is how we propose this alternative justice system that I'm going to present today. And we decided to focus on the narrow issues of displacement and destruction of property. So when I look at there was one question asked by Tafazo about how we can mainstream this. The Kenyan Constitution promotes the use of traditional dispute resolution as long as human rights are respected. So we have to have constitutional principles on public participation, inclusivity, gender balance, youth representation, leadership, and integrity. The second, which I find very progressive and which really espouses how African traditional mechanisms look at justice, is the Victim Protection Act. So these are some of the generous provisions that our law gives. The participation of an offender shall not be seen as evidence of admission or proof of guilt of the offense. There's no labeling. You're conflicting parties, but there's no labeling. Second of all, any party may withdraw from participating at any time. Third, where this process fails, the restorative justice fails, the court process can take over. And which I find also, the last provision I will share with you, which I find quite progressive, is that any agreement between the victim and the offender shall be recorded and enforced as an order of the court for the record. So you can agree between the two of you and you keep your document, but also the court will have that as record. So how did we constitute this alternative justice mechanism, given that we have the legitimacy of the community and we want to plug into existing legal frameworks? So we comprised a body, a committee elected by the community. And when I say the community, the offenders themselves also participated in selecting and designing this community mechanism. And so we trained them, and we ensured there was youth, women, and elders as well. and how they were running or listening to cases were based on traditional and customary values, plus existing enabling laws. There were 3 pillars that we held on to dearly when we designed this alternative justice mechanism. 1 was democratic participation, which I have highlighted. 2 was a space for truth-telling, as my previous speaker has said, it's a safe space for that. And 3rd was justice. And very important for us is indigenous or dialogical jurisprudence. Whatever is decided at that court becomes a formal, whatever is decided at this local committee at local level becomes a formal record of the court. So this process offered aspects of apology, reconciliation, truth-telling, and satisfaction, all the things that reparation talks about. And the question on enforceability. Yesterday we were talking about court-related reparations. Court-related reparations are good, but enforceability is always a challenge. What we noticed with these alternative justice mechanisms, the hearings were held in public. The community was there. The community witnessed. If you committed to returning 3 cows, you better return those 3 cows, because all members in the communities who were there would remind you at every corner that this is what you committed to and this is what you have to do. So enforceability from a community perspective was possible and it was sustainable. Now, some of the challenges, as I wind up, some of the challenges we had is the perpetrators, I'll use the word perpetrators for the purposes of this conversation, and the offenders who were willing to come forward were scared, because they felt that if they came forward and confessed to having committed a crime, they would paint their community as the perpetrator community. So this was happening within a very political context when the ICC cases were going on, because some communities were painted as perpetrator community, the other community was painted as a victim community. So if you come forward and say, I did this wrong, you'd be reinforcing whatever stereotype is there or whatever narrative is there at national level. So you will agree with me as Africans, it's very difficult to separate the individual from a community setting. So that is, as I wind up, that was one of the challenges that we faced. And so even if we try to promote individual to individual reconciliation, the involvement of the community was important, because in Africa, the individual does not exist outside of the community. Thank you.
Thank you so much, Amy, for that very illuminating presentation. In summary, I think you highlighted how the need for the African, for the alternative justice mechanisms arose also because that the formal justice system could not cope with just the numbers that were of cases that they had to do with after the post-election violence. And I particularly want to highlight what you said around how you had to reimagine justice, to look at it not only as retributive, but also look at the restorative elements, and the work that you did to bring legitimacy to these African justice mechanisms by connecting it through the constitution, the protection provided by the Victim Protection Act, as well as the key elements of the alternative justice mechanisms. You highlighted democratic participation, truth-telling, as well as justice, which is defined in terms of the indigenous jurisprudence. I think those are very important remarks, and I'm sure our audience will be eager to ask questions on that. But for now, we move on to John. And John is going to be discussing issues to do with the fumble took in Sierra Leone. John, before I hand over to you, I wanted to share with you a quote from David Crane, who is the former chief prosecutor of the Special Court for Sierra Leone. I don't expect you to engage directly with this court, but I just want you to be there in the air as you are presenting. So these are the ways that he said as a reflection, post facto, after the court. He said, I quote, "We approach the insertion of international justice paternalistically. I would even say with a self-righteous attitude that borders on the ethnocentric. We consider our justice as the only justice. We don't contemplate why the tribunal is set up and why, for whom it is being established. After setup, we don't create mechanisms by which we can consider the cultural and customary approaches to justice within the region." I hand over to you.
Thank you very much. Thank you to the organizers for this invitation. But on that quote, I'll pass. I'll start by giving you a brief background on our conflict. My colleague Bernadette shared yesterday a brief background that everyone in Sierra Leone at some point will say we are all victims. And as part of solving the problem, we had the Truth Commission, the Truth and Reconciliation Commission, and then the Special Court. I'll give you the cost. The Truth Commission, about $4 million. The Special Court, between $300 to $500 million to prosecute about 10 to 13 people. The Special Court did not make a single provision for victims. All of that money was for prosecution. There was nothing for Victims Fund. When I asked the coordinator, she said, oh, that was an oversight. That's just the background. So I was one of the human rights advocates during the conflict. We monitored the violations. We reported to human rights organizations. And at the end, we were not satisfied with the way the Truth Commission was handled and the Special Court. The Truth Commission stayed at the district headquarter towns. There was little or no provisions for communities to travel with their family. In Sierra Leone, if you offend me, you offend my family. So if you invite me to a Truth Commission, I cannot accept an apology without consulting with my family. So these are some of the flaws. I'll go back to my purpose here. Fambu Talk was designed to fill in those gaps. As I said, I was so involved in the Truth Commission. I was the chairperson for the TRC working group, a coalition of over 100 organizations by then. So after the Truth Commission, the commissioners, the 4 international commissioners went back to their country. The national commissioners were nowhere to be seen, but we were around. We kept the discussions alive. People came to us, what is happening? And during the process, I was able to facilitate the involvement of the amputees and war wounded to participate in the Truth Commission and the Special Court. At some point, they said they will not participate because the offenders were catered for as part of the DDR, disarmament, demobilization, and reintegration. But there was no provision for them as victims. They were told to go home in 2 months to leave their camps, or else the camps will be demolished. So we tried to negotiate and tell them, look, you have one more chance. The TRC will come up with recommendations, and hopefully there will be reparations, and there might be a provisions to correct the wrongs. Now, Fambu Talk. What is Fambu Talk? Fambu Talk is Creole for family talk. Because we as a nation, we are all one family. Before the conflict, it takes the village to raise the child. What went wrong? Why did we end up, attacking each other? I don't want to go back to what my colleague said yesterday, putting women in a house, set the house ablaze, our elders. I grew up in a village. If I'm walking to school, I will stop and help an elderly person carry her water or his or her water. These were some of the things we knew as a community. But then, the solutions never got back to those communities. We're talking of transitional justice. The voices of victims were ignored. The focus was more on the cameras in the city, in the big towns. So after all the cameras and everything disappeared, we had to deal with our challenges. That was how Fambu Talk was designed. First, we went to communities, because when I met with my colleague in the US, I said, look, if you are able to help us, I cannot give you a 1-year proposal. I can only give you a 3-month concept note, because I don't know if the people of Sierra Leone wants to reconcile, because there are journals that said people of Sierra Leone wants to move on. They don't want to talk about the past. But as a Sierra Leonean, I knew it was wrong. People of Sierra Leone want to talk. We want to move on, but we want to address the past, so we are better prepared to move on as community. So for time, I'll just keep all of that and we can talk on the side. So Fambu Talk is a program that was built on our tradition. We don't go into communities as experts. We go to communities as facilitators. We create a space for honest and frank conversation to take place in the safety of the community. The bonfire, I asked, it's not available. we use the bonfire as a space for honest conversation. It is the only space where in your village you can say things that the chief did to you during the conflict, and you will not be reprimanded. So we built the program on that tradition. Now, the premise is local solution to local problems. You cannot go to a community to tell them what to do. And it is not even one size fits all for Sierra Leone. Even in the different communities, they use different approaches to resolve their own, to conduct their own family talk. At the end of the hearing, the bonfire, they will have their traditional rituals to pour libation, to talk to their ancestors, to invoke the spirit of forgiveness and get them to continue as a community. It's important to include victims' voices in finding solution. That was our premise. What were the outcomes? Ownership. Fambu Talk in Sierra Leone is not seen as an outside program. People see it as their program. I remember when the first annual report was published. When I was walking into a village, a woman saw the report and said, "Oh, this is our report." No one would talk about that for the TRC report because it's seen as their report. No offense. What were the challenges in the Fambu Talk program? Like many other processes, there are challenges. One, respect for human rights. The tradition did not make space for women to be at the center of these discussions. So we had to find ways to encourage our traditional leaders. Please, when the war was going on, women were not excluded. So now we are finding a solution. They need to be part of the solution. Let's get them into this room. Children were asked to leave. We said, no, they were not asked to leave during the war. So how can you ask them to leave? Let them be around. Let them be involved in agreeing on the date to have a bonfire so they know they will be present. Inclusion, gender, these were also the challenges that we try to overcome in designing the Fambu Talk program. What were the contributions? What contributions can the process make? Presently, the reparations program ended after 8 years. The TRC recommendation suggested that victims who were as young as 9 months old should benefit from educational program until they reach tertiary level. Now, 8 years after, the reparations program dissolved. So what will happen to these people? What we are doing presently is we've gone back to these communities to say, what can we do as community members? So we realize we've got our land, plenty of land. So we are now using agriculture. We encourage these communities to plant economic trees that can bear fruit in 2 to 3 years. So as a community, they can support their kids. They can support each other to address the wrongs that were done during the conflict and even presently. Now, we are still using the Fambu Talk approach, the bonfire, to address contemporary issues in communities. So basically, this is a process that existed before the conflict. So we just try to sort of bring that back to the communities to say, these are ways that you can address some of your problems. There are certain problems presently that cannot be resolved through the Fambu Talk. They have to go through the court. But for time, I'll stop so far, and I'll say it's a real pleasure to come back here and have this discussion. Thank you very much.
Thank you so much, John. It's always a pleasure to listen to you. I think I've listened to you talk about the Fambu Talk a number of times. But every time I listen to you, it's always there's always something new to learn from what you say. I particularly picked a quote for something that you said. You said, in Sierra Leone, there was a perception that if you offend me, you offend my family. And you highlighted how this is a reflection of the Afro-communitarian philosophy around how the individual is defined in relation to the community. I think in some instances it's called Ubuntu, Hunu, and different versions of the same philosophy around how you cannot just have your own personhood as an individual without being a part and parcel of the community that you belong to. And you also explained how then this feeds into how the Fambu Talk operates where it does not just focus on the individual perpetrator and the individual victims, but it includes the families of these two parties. It also includes communities that are there and the role that they play in this particular process. Interestingly, you also mentioned something about ancestors and the role they play in terms of fostering forgiveness, which makes me recall something that one of the traditional leaders in my country said to me. He said, we convene over the living and the dead. So in essence, what he was explaining is that when you talk about reconciliation and justice in Africa, it goes beyond just looking at those who are around, but also looking at those that have departed. Thank you so much for those words. I will not go on and waste time. I will move on to Nesma, who's going to talk about the traditional healing rituals in North Africa. I'm trying to look at the back. There's a gentleman who was supposed to cue a video. So please be ready. When I tell you, please show us the video. Oh, there is no video. There is no audio. Nesma, I think you'd have to go without it. I'm sorry. It was going to be good to see the video. Maybe what we can do is maybe we'll talk to the organizers and circulate the link so that colleagues can be able to see the video on their own time. Thank you.
Thank you so much. Okay, someone is dealing with it. All right. Okay. Thank you so much. Pleasure to be here. Good morning, afternoon. My name is Nesma. I'm from the African Union. I'm an expert on Libya. I've been working on crisis conflict management. And can we leave it for the end, please? If it's possible, just to stop it. And thank you so much. Yeah. But today I will be talking about a different thematic I'm used to work on my, I would say, my daily duties. I'll be talking about traditional healing rituals, and I'm going to enjoy the fact that we have interpretation. Sorry, Dr. John. I'll be delivering my presentation in French. I'm much more well-versed with the vocabulary of the topic I'm going to talk about. Donc, leaving some time for people to put the headsets. Donc, je vais vous introduire à des pratiques ou des rituels thérapeutiques traditionnels qu'on pourrait éventuellement retrouver un petit peu partout dans le continent, mais également dans le monde, et qui sont propres à la région de l'Afrique du Nord. Et il s'agit des rituels en fonction des régions, donc évidemment le nom peut varier et changer. Il s'agit des rituels diwan ou les rituels gnawa, donc pour spécifier l'ère géographique. On retrouve ces rituels donc, de guérison en Algérie, au Maroc, en Tunisie, en Libye et peut-être éventuellement en dehors de la région du Maghreb, notamment en Égypte et au Soudan. Donc c'est un répertoire qui est le fruit d'un mélange de cultes, donc syncrétiques, relatifs aux saints, des saints ou des ancêtres en fonction des croyances religieuses qu'on pourrait avoir, et qui est issu d'un héritage culturel africain et soufi maraboutique maghrébin. Donc l'Afrique du Nord ayant pour tradition l'islam maraboutique. Et il s'agit de musique, de sons qui guident la transe et la danse, on va dire, des adeptes lors de ces rituels, souvent nocturnes, qui mêlent la fête et l'action thérapeutique. Les musiques et les intentions dirigées visent à évacuer les maux dont souffrent les concernés qui viennent participer à ces rituels. Donc sur des rythmes et des sonorités plutôt entraînantes et envoûtantes, les trans ont lieu pendant des heures et parfois même sur plusieurs jours, on va dire 3 jours, en fonction des besoins de chacun et de l'état de souffrance, on va dire, de ceux qui y prennent part. C'est aussi un genre musical mystico-religieux qui répète en litanie des invocations. Donc un appel aux ancêtres, un appel aux saints, sur des rythmes qui associent le ternaire et les binaires. Donc je ne sais pas s'il y a des musiciens dans la salle, mais ce sont des rythmes en 3 temps et à 2 temps qui ont un effet très très entraînant sur le cerveau et qui aide à lâcher prise ou à entrer dans d'autres dimensions de l'être. Donc l'objectif de ces rituels est le traitement thérapeutique, comme je l'avais dit, à travers les invocations, donc des saints, des entités invisibles, dans le but de soulager les maux psychiques et physiques. Dans la croyance populaire, la somatisation requiert un besoin de guérison par la voie de la thérapie traditionnelle qui se manifeste sous forme de transe et d'entrée en état de possession. Donc ceci nous amène à nous poser la question suivante, à savoir à travers quel médium se fait l'entrée en état de transe extatique en vue d'une éventuelle guérison. Alors on est dans un cas de figure où la guérison reste la seule option de guérir de ces maux éventuellement et que tous les autres moyens ont été épuisés. Donc la réponse est toute simple. Donc cela se fait par le biais de la frénésie des sons, de la musique. Donc il y a un certain nombre, on va dire une certaine catégorie d'instruments, des instruments à cordes, des instruments de percussion très puissants, des chants particuliers, mais aussi le mouvement des corps. Donc je reviendrai par la suite sur le mouvement des corps et son importance, donc les danses. Avec une interférence des symboles et des couleurs. Donc les couleurs sont présentes à travers les habits. Donc c'est dire que le visuel est extrêmement important pendant ces cérémonies. Donc ces cérémonies sont codifiées et séquencées, dans lesquelles on appelle à la délivrance de l'âme, des souffrances transgénérationnelles passées forcément, mais également celles du présent et pour prévenir des souffrances qui sont à venir. Je rappelle que ce sont des rituels ancestraux homogènes et quasi intacts malgré le passage du temps et des siècles dans la région du Maghreb. L'interaction avec les entités permet de leur conférer une sorte de contrôle sur soi, sur la base de la croyance populaire dans la région. Et des communautés notamment qui s'adonnent à ces rituels. Et donc on est dans un contexte en fin de compte de transe libératrice, mais qui reste contrôlé par des agents qui sont présents et qui accompagnent ces cérémonies et leur déroulement. Donc en somme, c'est une forme de thérapie sociale qu'on retrouve également dans d'autres régions du continent, au Mali, Tombouctou, si je ne dis pas de bêtises. Elles sont similaires aussi aux simpes pratiquées au Sénégal et au bourri, au Nigeria. On retrouve aussi cela, on va dire ces similitudes sont retrouvées aussi au Brésil, donc à travers le candomblé. La santeria aussi à Cuba et à Haïti, et ce sont des rituels qui relèvent foncièrement d'une dissociation identitaire et qui sont ouverts aux groupes, tout type de groupes déjà, mais surtout des groupes marginaux, des groupes vulnérables, mais pas que. Je reviendrai là-dessus. Pour ce qui est de l'aspect psychanalytique donc, et socio-anthropologique et culturel, les chercheurs trouvent que la transe recalibre les relations entre soi et les autres, et cela à travers le mouvement des corps, des danses, des émotions et des ressentis que cela peut susciter. Donc toute douleur est en fin de compte relationnelle, tout comme la transe thérapeutique dans ce type de cérémonie. Et c'est l'une des principales raisons pour laquelle la transe aide à canaliser la souffrance. Je citerai l'éminent scientifique de l'Université de San Diego, Thomas Ordaz, qui a consacré à l'ensemble de son œuvre au rituel de guérison et qui décrit les approches somatiques comme des explorations corporelles qui utilisent la perception des sensations et des mouvements pour le plaisir, pour la relaxation et pour l'autorégulation des humeurs. Donc, les pratiques somatiques visent à éveiller la conscience corporelle, la conscience n'étant pas seulement cérébrale, à travers la perception attentive des sensations et des mouvements, donc des danses. C'est ce que qualifient aussi à leur tour les neuroscientifiques comme la pleine conscience, qui modifie le cerveau et régule les émotions. Et pour terminer mon propos, donc, on a noté dans pas mal de, on va dire, de pays qui ont connu certaines crises et qui sont notamment passés par des expériences douloureuses de conflits armés avec tout son lot de conséquences et de douleurs, un engouement assez important pour ce type de cérémonie qui leur permettait de mieux se sentir. Merci pour votre attention et j'aimerais qu'on puisse diffuser la vidéo si c'est possible, ou du moins un petit extrait.
Thank you. I also asked you if you can show the photo that I shared with you for the Fumble Took rituals. It would be great. Well, yes, the bonfire. This is, I think, what John was talking about in terms of the Fumble Took, just to show you the bonfire. Interestingly, you can see the presence of children and women, as he highlighted, that to ensure inclusion in this particular ritual. Thank you so much to all the participants for their presentations. I think now I would like to open it up to you, to colleagues, to also pose questions. I think the beauty about this session is we've already set the tone, and we spoke about the Afro-communitarian principle in terms of you thinking of your fellow human being, fellow brother and sister. So we will apportion 10 minutes as a collective, which we can share among ourselves depending on how we want to share it. So please be conscious that the person next to you also wants to ask a question. So be brief and move on and allow our other colleagues to also ask their questions. The moment we are done with the 10 minutes, I will stop taking questions and I will dedicate a bit more 10 minutes to the panelists for them to respond to the questions that they want to respond to and also give their closing remarks. With that, our 10 minutes starts now. So can I see by a show of hands? I see 1, 2, 3, 4, 5, 6. Let's work with those 6 and let's try to ensure that all of you can speak. Remember, you only have 10 minutes shared among the 6 of you. Let's start with that. Do you have a roving mic? Do you have a mic somewhere? We move around. Yes, please move around the mic if you can. I counted 6. 1, 2. Can you show me again by show of hands? Please look at the people so that you can know who to give the mic. Please, can you raise your hands again? The 6 people that I counted. My sister, it's 1, and the gentleman behind you, 2, 3. I think you had the hand up. Was your hand up? 4, 5, and 6. Sorry? Okay, let's move it around and let's see how far we can go. Please go ahead with your question or comment. Please keep it brief.
Merci beaucoup. Bonjour à tout le monde. Je suis Dr Arnaud Yaliki, je viens de la République centrafricaine et depuis avril 2025, j'ai prêté serment comme commissaire à la commission Vérité, Justice, Réparations et Réconciliation. Je suis totalement d'accord avec les commentaires des panélistes au sujet des mécanismes judiciaires de réparation qui sont très importants et je voudrais partager avec vous une expérience de la Cour pénale spéciale dans une décision qui a été rendue. Je pense que c'est une affaire de Kondjili et Lemuna qui est portée devant cette cour et la chambre d'instruction avait souhaité ordonner la construction d'un mémorial comme une forme de réparation pour permettre la reconstruction de la mémoire. Et puisque la demande a été formulée, la chambre préliminaire, avant de prendre une décision, avait dépêché une mission sur le terrain pour se rassurer si elle prend une telle décision, est-ce que la décision serait acceptée. Et quand la mission était arrivée sur le terrain, on a interrogé les présumées victimes, la population, qui ont donné un avis contradictoire pour dire que dans notre culture, dans notre tribu, construire un mémorial pour les atrocités de masse va constituer une malédiction pour notre tribu. Ça va appeler les malheurs sur nous, ça va appeler la mort sur nous. Donc nous ne voulons pas la construction d'un mémorial. Donc cet avis-là a permis à la chambre préliminaire de ne pas octroyer cela comme une mesure de réparation. La leçon ici à tirer, je finis rapidement, c'est que ces genres de décisions interviennent dans des contextes douloureux et que le juge, avant de prendre une décision, doit se rassurer que vraiment cette décision est adaptée à la réalité des victimes. Voilà très rapidement la contribution que j'aimerais apporter au sujet. Voilà.
Thank you so much. Thank you so much. Please, can we keep it as brief as possible? Thank you so much.
Thank you so much. Mine is very short. Looking and hearing at all of your presentations and also looking at the discourse around transitional justice across the continent, you would agree with me that priority is often given to criminal accountability, which is very much Eurocentric, and we give less accountability. Actually, I can say traditional mechanisms become an afterthought after we try all the Eurocentric approach to transitional justice. So that attention, the level of attention we give to traditional dispute resolution mechanism is very clear in terms of budget, in terms of institutional arrangements, and in terms of also the way we approach donors who are funding our transitional justice initiatives at the local level. So how can we do that way around, and start actually with the traditional justice mechanism, which we say victim-centered, restorative, and closer to our community? That's the question that I'm trying to get a resolution for. Thank you.
Thank you. There were hands, please. Let's be faithful here and honest. If you're counted among the 6, please keep your hand up, but don't raise a new hand. You take over someone's slot. For the 6 people that we counted, now we've taken 2. We are waiting for 4 more. Where are the other 4? Can I see the other 4? Please give the mic to, there was a hand somewhere here. I think to with here.
Hi, thank you. It will be brief. My name is Victoria. I'm with UNDP, and I would like to just reflect a little bit on what was shared by Nesma. I'm originally from Brazil, from an area called Bahia, that it's an area that is a strong Afro-Brazilian community, and the healing rituals and the traditional means are the same. And I think it's fairly important for us to reflect that very often, hopefully some of these practices have crossed continents, and we are still having a way to maintain those practices even despite colonialism and so on. So it was heartwarming to see that in Algeria some of these practices are still being used, and the connections are immense, and the shared struggle. Thank you.
Thank you. I think there was a lady with a hand up there. And there was also another hand. Okay, there, yes.
Mine is just a contribution, especially regarding the issue of human rights and gender perspectives on traditional justice mechanisms. I think we need to exercise a little bit of caution in terms of casting these mechanisms as not human rights sensitive or entirely masculine, because I know that for some of the traditions that we studied, the healing processes are heavily supported by women. The different herbs and healing processes that some of the victims and perpetrators go through are actually heavily supported by the elderly women who actually go through these processes. And then also the mediation processes are highly supported by women. So when we say that they are flawed because they are not human rights sensitive or gender sensitive, we need to be really specific about those areas. And I remember that when we made recommendations in terms of approach. If it's a decision probably that is going to be made, maybe that's where the aspects of inclusivity and human rights can be captured. And then when it came to punishments in traditional Africa, there are certain punishments or certain atonements that was seen as overboard. For example, in the case of killing, when a person was killed in certain traditions, a girl was given as reparation to that community. So those are some of the areas that I believe that in some areas have already been extinct, and those are the areas that we should really focus on. Is it the punishments or is it the process of reconciliation, healing, and accountability that we are looking at in a transitional justice process? Thank you.
Thank you. Can you please move the mic? Thank you.
Merci pour la parole donnée. Je suis Antoinette Sambrou du WILDAF Afrique de l'Ouest. Félicitations d'abord aux panélistes. Les mécanismes que vous avez partagés avec nous, pour moi, pour être efficaces, devraient intégrer les besoins des communautés, comme mon grand frère de la Sierra Leone l'a si bien dit. Et qui parle de communautés parle forcément des femmes, parle forcément des groupes marginalisés. Depuis hier, nous en avons parlé. Je voudrais savoir alors, comment ces mécanismes au niveau du Kenya, au niveau du Burundi, comment ces mécanismes intègrent les besoins spécifiques des femmes et au-delà des femmes, comment ces mécanismes intègrent les besoins des groupes marginalisés. Merci.
Thank you. There's one more hand there, please.
Thank you so much. Good morning, all. So my question, comment is, how do we marry these traditional processes with accountability, legal accountability? I say that because I know in the Gambia, our organization, we have what we call the Karabengo, Kakairo Balo initiative, which is peace talks for peace building, individual and community healing, and reconciliation. And in that process, we also look at the traditional for people to talk. They come out and talk. And we also kind of fashioned it a little bit around Famble Talk, because that was one of the case studies we used to be able to document. And in Famble Talk, I know, because I follow it quite extensively, you have people standing up and saying, I killed your family member, I am sorry. That's an admission of a legal crime. So later, the long arm of justice, how does that exonerate you, if at all? Or how will you be impacted by that open admission of guilt? It's something which goes around my head, and I'm glad we can have this opportunity to talk about it in ways we can. I don't have all the answers, and that's why I would really appreciate some insights into that. Because I have my thoughts, but let's see how it goes. Thank you.
Thank you so much. Colleagues, you do have to forgive me. The 10 minutes is up. I think the panelists have heard some of the questions, all the questions, and as well as the comments. So I now hand over to the panelists to to respond and also give your parting words in the same process. I would say if we share the 10 minutes among the four of you, probably 2.5 minutes each, just to respond and also just give your closing remarks. I'll start from you, Patrick, and we'll go this way. Please start.
Bon, merci beaucoup. Il n'y a pas beaucoup de questions qui m'ont été posées. Il y a la question de Madame intègre les besoins des femmes. Bon, vous vous souvenez, j'avais mentionné la recherche qu'on avait fait en 2016. Alors là, j'ai été dans la partie ouest du pays, là où généralement ces mécanismes, j'avais trouvé que dans cette partie, les mécanismes fonctionnaient particulièrement bien. Et ce que j'ai retrouvé, c'est que à côté du groupe, ou bien du conseil des sages, qui étaient essentiellement des hommes, ils avaient décidé de créer un autre conseil fait par des femmes que l'on considère comme des modèles au sein de la communauté. Alors, chaque fois qu'il y avait un problème au sein de la communauté qui concernait essentiellement les femmes, c'était dirigé vers ce conseil des femmes qui était en charge donc de voir si ils pouvaient trouver une solution. C'est donc cette solution qu'ils avaient trouvée. Bien sûr, je ne sais pas comment ça se passe dans les autres parties, mais je sais que ces mécanismes de justice traditionnels s'est éparpillé un peu partout en Afrique. Et je trouvais que le fait qu'il y a toujours cet espace qui est ouvert, où on permet à tout le monde de s'exprimer. Souvent, même si les femmes ne font pas partie des conseils, elles ont quand même le droit à la parole. Elles peuvent s'exprimer et présenter leurs doléances, parler de leurs problèmes. Et je pense que c'est de cette façon qu'on essaie d'intégrer. Peut-être à notre niveau aujourd'hui, parce qu'on en parle, ce serait d'insister, d'essayer de sensibiliser sur la nécessité d'agrandir l'espace et de permettre aux femmes d'avoir un espace spécifique, parce que parfois on trouve que elles ont des problèmes qui sont spécifiques à elles, et ça doit être pris en considération. Merci beaucoup.
Thank you. The question on the donors about, treating traditional mechanisms as an afterthought after every other thing has failed. It's a lesson. It's a painful lesson I take with me every day. And that is something I realized that perhaps we should have started with. I think donors now, even to that, and we are looking at it through a very progressive lens. When it comes to the question of integrating the specific needs of women, our constitution is very clear as to how we're supposed to include women in any mechanism, any decision-making process. And there have been lots of cases that have been decided on that. So for us, it's what we are struggling with are dealing with these community challenges. The last thing is community conflicts. The last thing was on the question of accountability. How do we marry traditional process with accountability? I look at accountability at two levels. Are we looking at it at criminal accountability or communal accountability? I think for communal accountability, once there's acceptance of wrongdoing, acceptance to pay or do the punishment, and generally the community sees that you're sorry, there's accountability at that level, where there's going to be a gap at criminal accountability if the family or the conflicting parties involved do not decide to take it through a criminal accountability process. At least from my experience and in the Kenyan experience, communal accountability was so heavy as compared to criminal accountability. But then again, that is very context specific.
Thank you so much, my friend from Brazil, regarding your intervention on the candomblé. Actually, as you mentioned, I think it's very important to maintain these traditions, but also to make them known and renowned, given their very, I would say, their high therapeutical benefits. And this is something we shouldn't be undermining. Transitional justice is important, communal justice is important, but also I think we need to work on our own self-justice through our very traditional rituals in order to heal. because healing is not it shouldn't be just on papers. It's a genuine feeling that we all need to experience and experiment in order to move forward in our lives. Thank you so much.
Thank you. I'll touch on two of the questions. The role of women. In the Famble Talk process, women are at the center of the solution because they are mothers, they are sisters, and they can talk to their husbands, they can talk to their kids. So, and when the program started, I was shocked at the first bonfire to hear women accuse their family members that they raped them in front of the community. I was like, wow, this is not common. So I don't have the solution. I called my colleagues. How do we solve this? Go back to the women, consult with them. How can we solve this problem? And they said, bring us together. We'll find ways to support each other. So they were able to come up with a women's support group called Peace Mothers. And they are very active to date. So women, when they say yes to peace, it's sustainable. I can confirm that. How do we marry traditional processes with accountability? Sometimes we fail to realize that the definition of justice is imported from the West. If you talk to the person in the village in Sierra Leone, when we consulted with the people in communities, say, who bears the greatest responsibility? They don't relate to those who were prosecuted. They don't know them. As the person who led the rebels to their village, that's the person they want to talk to, the foot soldiers. And justice can be defined as, to them, it's acknowledgement, public naming and shaming. And the way it is resolved is not just you, the individual. When you come forward during the bonfire, when you acknowledge what you've done, you bring in your family. And that is a way to say never again. Because you don't want to embarrass or humiliate your family for the second time. And your family will always be there to say, hey, don't do this, don't do that. So it's important for us to define justice. But I also want to add that in Sierra Leone, we were able to do this because there was a blanket amnesty. But there was one case where a warlord, sort of, called Mr. Dai, he was on the list for prosecution. He went to prison for a couple of years. But he came to me and said, look, I want to go back to my people. I want to apologize to them for what I did. We had to negotiate with the court, negotiate with the chiefs, etc., for him to go back. And that was the greatest gift he said he has ever had from the conflict. So basically, in closing, I want to say what I've said here, Famble Talk is not an event. It's a process. For us to get to the bonfire, we'll spend like 3 to 4 months in a community before we say, yes, it's time to have this space. So basically, I know you're coming for the mic. Thank you very much. Okay, but it's really important not to treat reconciliation, healing as an event. It's a process. We have follow-up activities after the bonfire. We have football for reconciliation. No winner, no loser. Women play 15 minutes apart. Young boys play. The elders play. At the end, they have a disco. I'll give you one fun. The first disco, we took the set away at about 4 in the morning. That was the greatest mistake. Because they used the disco as accommodation. So they dance all night until the morning. It brings the perpetrators and offenders together. It sort of bridges the gap. And we also have community farms where they work for a couple of months and then they come together to share the proceeds. These are all follow-up activities. And finally, we also have the peace tree. The peace tree is a space where you can take unresolved issues from the bonfire. Like one of the women who testified, the man said, well, yes, I accept it. But the woman said, I will not shake your hands until you explain everything. He killed his husband, he killed his child, and then he forced her, to be bushwife. She wanted him, because he was now a stakeholder in the community. He wanted him to explain all of that in front of the community. So that is justice. Thank you very much.
Thank you so much. I think you can agree with me that it's been quite a journey. We've traveled from the Great Lakes region with Patrick accompanying us and he gave us a guide in terms of some of the key features of the African justice mechanisms. And then we went all the way to Kenya, and we zeroed in Kenya with Amy, you have to forgive me by the way I'm pronouncing your name, who took us through the alternative justice systems in Kenya. And then we went to Sierra Leone with John, and John took us through the bonfire and the fumble took processes and their significance. And lastly, Nesma, you took us to North Africa and you shared with us those very powerful healing rituals. And you also showed us how music, colors, and dance play a critical role in terms of the healing process. And interestingly, I think it was a befitting close to this session where you highlighted the connection between the physical healing, the mental healing, as well as the metaphysical healing or spiritual healing that you also mentioned. So it's been quite a ride. My final concluding words would be, I'm sure all the panelists here, including myself, we are not advocating for a zero-sum approach where we are saying these African justice system processes are there to supplant, completely substitute criminal accountability or other formal justice systems. But at the same time, we are also boldly stating that these particular mechanisms are critical mechanisms and they do work. I think it was Patrick who said, in some context, in my head, I remember there was a research around in South Sudan, 80% of the people were more inclined to use the customary than the formal justice system. So these are systems that work. As I close, I would just want to leave two challenges to the group and to everyone here. The first one is for us to keep thinking in terms of how do we integrate these African justice system processes into our formal transitional justice processes. How do we include them in the national transitional justice policy of our respective countries? How do we include them in our programming as CSOs wherever we are? And the last challenge I give you is, beyond just including them as separate mechanisms, how do we learn from them in terms of, for us to be able to understand better our own African conceptualization of justice? I think from the presentations you've already seen, I will just summarize some of the elements I was taking down from the presenters. It came out clearly that in our African context, justice is individual, it is also collective, it is social, it is reparative, it is transformative, it is concerned with personhood, it concerns livelihoods, it is concerned with dignity, it is ecological, it is metaphysical, it is spiritual, it concerns both the living and the dead. It is transgenerational, it concerns the past, the present, and the future. Thank you so much for your attention, and thank you so much to the panelists for your time. Prof Bakam, thank you.
Je vous demande encore d'applaudir pour le modérateur ainsi que les panélistes. Vous conviendrez avec moi que c'était très intéressant comme panel. Nous allons observer une courte pause de 15 minutes et puis nous allons poursuivre avec la dernière session qui va porter sur le rôle de l'Union africaine, des REX ainsi que des académiques dans la promotion de réparations. Donc nous allons revenir ici après 15 minutes.
Can we please settle down so that we start? Our panelists should please come to the podium. Please let our panelists come to the podium. Professor Makayas. Professor Makaya, where's Professor Makaya? Where is he?
Nous allons reprendre les travaux. S'il vous plaît, prenez place. Alors, la dernière session du forum sera modérée par le docteur John Ikubadje, qui est le chef de l'unité justice transitionnelle de la Commission de l'Union africaine. Comme je l'ai annoncé, cette session portera sur le rôle de l'Union africaine, des REX, du monde académique et de la société civile dans la promotion des réparations. Je vais donner donc la parole à Dr. John sous vos applaudissements.
No, thank you very much, Professor Eugene Bakama. Good afternoon, everyone. We're supposed to have 4 panelists in this section, but unfortunately the 4th panelist is not around, so we are going to be having 3 of them. The first one is going to be the one at the center, Mr. Koku Agbani World Ahmed, from the Office of the African Union Citizens and Diaspora Directorate. We also have Ms. Ruth Ogbewekon, Project Lead, Reparative Justice at the Pan-African Lawyers Union. And finally, we have Professor Blaise Takaya, who is a judge of the African Court on Human and People's Rights, and also an academia. We are going to take it very fast because Professor will be leaving as soon as possible to the airport to catch up with his flight. But having said that, let me welcome you to the last but certainly not the least section of the forum, focusing on the roles of the African Union, regional economic communities, region and academia, and also the civil society in advancing reparation in Africa. Yesterday, some of you that were here, you will see that the first day was devoted to the roles of the member states on reparation. And during the course of the session, we have a presentation from Togo, Gambia, Morocco, and also South Africa and others. So this afternoon, which is the last section, we will be focusing on the roles of the African Union regional economic communities, civil society organization, and also the academia. Let me say this, that some of us that are familiar with the African Union transitional justice policy, you will realize that reparation is one of the 11 core elements of the African Union transitional justice policy. And so reparation is at the center of the African Union program on transitional justice. And you will agree with me, like there is a saying, a common saying in human rights and transitional justice pillars, that human rights and transitional justice are our collective responsibility. And so both the member state, the regional economic community, it is all our responsibility to promote effective implementation of reparation. And let me start on this note, that I may not be able to say much on the roles of the regional economic communities, academia, and civil society on reparation. But to a certain extent, I think the African Union is beginning to become fit for purpose on reparation. If you listen to one of our panelists this morning, the question he asked, is African Union fit for purpose? But on this particular subject, I think we can say that the African Union is beginning to become fit for purpose on reparation. And by declaring the year 2025 as the African Year of Justice for Africa and People of Africa through reparation. Now, in addition to that, there are some things that I will just talk briefly on the roles on what the African Union has done in this particular area on transitional justice and reparation. The first thing is the adoption, is the development and adoption of the African Union transitional justice policy in 2019. And you will agree with me that that policy is today shaping transitional justice implementation across the continent, and that's one of the reasons why we are here today. In addition to that, another critical role that the African Union has been playing on reparation is providing technical assistance to member states on implementation of their reparation programs and mechanisms. And we can cite some few examples where the African Union is currently working. In the Gambia, for example, we provide technical support to the Gambia Reparation Authority by training members of the Reparation Authority. Similarly, we are also providing technical support to the South Sudan. We support them. We are trying to support them in operationalizing the Reparation Authority. Same thing is we also apply in Lesotho and in other countries where the African Union, together with our partners, CSVR and others, we are providing technical support to member states on implementation of their reparation program. One important thing that may not be known to many of us is the establishment of what we call the African Union Peace Fund. Today, the African Union Peace Fund is running to 300-something million, and one of the things we plan to do is to also see how the African Union, through its Peace Fund, can support member states implementing their reparation program and transitional justice. We intend to support, for example, the Ethiopia and also South Sudan in this area of reparation. And in addition to that, with support and collaboration with the European Union, we have also been supporting the civil society organization to play their critical and primary role on reparation. And so across the continent, with African Transitional Justice Legacy Fund and other partners, we have been providing sub-grants to some of the civil society organizations, including in DRC, where we are providing support through grants to civil society organizations in support of implementation of transitional justice and reparation in DRC. In addition to that, the AU is also working with the academia to interrogate transitional justice and reparation, leading to different publications. Some of you that were here during the first day, there was a distribution of a publication on the state of Reparation in Africa, Transitional Justice and Reparation Africa. We have been working extensively with the members of the academia to work in these particular areas of research and also publication on reparation. But this afternoon, we have able panelists who is going to do justice to the subject matter. Without much ado, because our first speaker will be catching his flight by 2 o'clock, so we are going to call on Professor from the African Court on Human and People's Rights to give us the roles of the African Union and other statements that are relevant in this regard on reparation in Africa. Professor, over to you. We'll just give you 10 minutes.
Merci. Je m'appelle Blaise Chikaya. Je suis professeur de droit international et actuellement juge à la Cour africaine des droits de l'homme et des peuples qui siège à Arusha, en Tanzanie. Je vais donner quelques observations sur le sujet qui m'est soumis. Je commencerai d'abord par remercier et saluer l'initiative des organisateurs de ce forum sur un sujet, on l'a vu, qui est de toute importance par rapport à l'histoire actuelle de notre continent, l'Afrique. Alors, je suis que l'un des juges à la Cour. La Cour africaine est constituée de 11 juges de différentes nationalités africaines et les délibérations des juges sont, vous le savez, absolument discrètes et on tient des réserves qui nous est imposées par le protocole signé à Ouagadougou de se tenir loin du contenu des délibérations. Je vais donc donner des opinions qui ne sont que les miennes par rapport à la participation de l'Union africaine à cette œuvre énorme qui est la justice transitionnelle telle que décidée par la conférence des chefs d'État. En ce sens, je commencerai par une remarque sur ce que l'on peut lire ici écrit au tableau. Il est noté que la forum porte sur l'état de la justice traditionnelle en Afrique qui se juxtapose sur la justice pour les Africains et les personnes d'ascendance africaine à travers les réparations. À proprement parler, la superposition de ces deux notions ou ces deux expressions pose un problème dans l'entendement juridique. Il faudrait, de l'avis et à la lecture des juges de la Cour africaine, il y a comme une approximation que de considérer que la façon dont on doit aborder les violences et les violations issues de l'histoire de l'Afrique, l'esclavage et la traite, ces questions sont absolument différentes. Les problèmes juridiques qui se posent à ce niveau sont absolument différents des questions liées aux violences quotidiennes et nationales que l'histoire actuelle de l'Afrique peut produire. Si l'on distingue les deux, il va de là que le droit applicable tel que cela a été retenu par les États fondateurs de la Cour africaine, qui est l'organe juridictionnel africain, si l'on fait cette distinction, l'application de l'article 3 qui dit le droit applicable en cas de violation et d'atteinte aux libertés et aux droits des personnes sur le continent va poser un problème. Il faut donc interroger la distinction qui doit se faire à ce niveau pour savoir exactement le droit applicable. Ce n'est pas le même droit. C'est vrai que dans la façon dont on a amené cette question, on pourrait dire, entraîné une sorte de confusion entre les violences coloniales et historiques de l'Afrique et les violences qui sont certes importantes aujourd'hui en Afrique. On parle, ce sont des violations continues, ce sont des violations permanentes et même des exécutions, et on les a encore évoquées aujourd'hui, qui sont déplorables et inacceptables sur le plan humain, mais elles sont en distinction avec les violences historiques liées à la traite et à l'esclavage que l'Afrique a connu. Cette distinction me semble être la première. Et la contribution que la jurisprudence de la Cour africaine apporte vise aussi à noter que, et là aussi c'est un problème dans notre raisonnement, la façon dont nous travaillons sur ces questions, le droit qui est applicable lorsque nous parlons de justice traditionnelle, c'est absolument du droit international. Pour une raison fort simple, parce que le droit des personnes, les droits des humains, n'est pas sécable. C'est-à-dire qu'on ne distingue pas un humain qui soit africain et un humain qui soit américain ou européen, à l'échelle du droit international. Et donc, c'est en cela que ce droit-là est un droit de l'homme, et non pas un droit qui puisse être distinguable du droit dans une région ou dans une autre. Et cette dimension est en général un peu perdue de vue dans le raisonnement courant. Et la Cour africaine des droits de l'homme d'Arusha a sans cesse rappelé cette donnée, et c'est pourquoi nous devons nous y référer particulièrement. Par ailleurs, dans les travaux de la Cour africaine qui va fêter sa 20e année d'existence, il a été rappelé dans des jurisprudences comme la jurisprudence sur les OGEC, l'affaire du Kenya, et pour laquelle la commission de Banjul a saisi la Cour africaine. Il a été rappelé que toutes les fois où le continent a traité une violence, cette violence doit être traitée à l'échelle panafricaine et non pas dans une échelle ou dans une dimension nationale. Parce que les violences ont les mêmes ressorts, ont les mêmes sources en général, que les sources de cette violence se produisent au Congo, au Sierra Leone ou dans un autre pays africain. Les sources des violences sont toujours les mêmes en général. Et donc, ce que la Cour africaine rappelle dans des décisions comme les OGEC, la décision de 2024, dans sa décision sur les mérites, sur le fond, la Cour rappelle que ce droit-là, le droit qui est applicable, même dans une justice transitionnelle, qui est simplement une justice, elle n'est pas transitionnelle, elle est transitionnelle dans le langage voulu, en termes de facilité de communication, mais c'est une justice internationale, une justice panafricaine. Et ça, on le retrouve dans la décision que la Cour rend dans l'affaire OGEC, et cela doit être rappelé à suffisance. Et dans une décision qui se trouve dans la continuité de la jurisprudence OGEC, on trouve une autre décision que la Cour a rendue en 2022 dans l'affaire Bernard Morna, un ressortissant ghanéen qui saisit la Cour pour les problèmes que le Maroc, encore une fois de plus, on a été saisi par un citoyen ghanéen, et dans cette jurisprudence Bernard Morna, la Cour rappelle l'implication de l'Union africaine dans la pacification du continent en matière de protection des libertés et des droits des personnes. Et on retrouve dans cette décision un obitaire dictum de la Cour qui rappelle les droits que l'Union africaine, l'organisation panafricaine, la façon dont l'organisation panafricaine doit veiller à ces droits. Et j'aimerais insister là-dessus en disant que lorsque l'on tient compte des quatre piliers de la justice traditionnelle, on en arrive à une notion qui est fondamentale au final. C'est la réforme institutionnelle du continent. Et sur ce point, la Cour africaine, dans la vingtaine d'années qui viennent de s'écouler, a rendu nombreuses décisions sur la façon dont les institutions africaines doivent être adaptées, doivent s'organiser pour assurer la protection des droits des personnes, la protection des libertés et la protection de la sécurité et de la paix sur le continent. Sans citer les pays, j'aimerais rappeler les décisions que la Cour a rendues sur le Bénin, sur la Côte d'Ivoire, dans lesquelles, par exemple, la Cour a rappelé que la création d'un organe spécial qui serait en distinction des juridictions nationales, je dirais régulières, par le pouvoir central, n'était pas acceptable dans la protection et dans la préservation des droits des personnes. Je pense, par exemple, à la criette qui avait été créée au Bénin. Et la Cour a travaillé là-dessus et a rendu des décisions qui peuvent être consultées sur Internet. Et ces décisions, à mon sens, donnent une dimension importante dans la façon dont les organes de l'Union africaine, la Cour africaine des droits de l'homme et des peuples contribuent aux instruments qui vont nourrir cette justice traditionnelle. Et je pense que cela est très important. Il y a par exemple la décision Zongo qui concerne le Burkina Faso. Cette décision apporte de la matière à la façon dont les États sur le continent peuvent respecter les droits sur la liberté d'expression et également peuvent assurer un meilleur fonctionnement des organes internes pour préserver les libertés et fondamentalement respecter les droits auxquels les individus peuvent prévaloir. Alors, je vais dire qu'en une vingtaine d'années que la Cour africaine existe, il y a une évolution en profondeur et une contribution en profondeur que la Cour africaine, qui a son siège à Arusha, pour le rappeler, donc en Tanzanie, contribue à l'évolution du droit institutionnel et les droits des libertés dans le continent. Je ne vais pas être plus long parce que je suis rappelé à l'ordre de tous les côtés et je vous remercie pour votre attention. Merci.
No, thank you very much, my Lord, Professor. The common saying that, the hope of a common man, that the court is the hope of a common man. I don't know whether we can conclude on that in this regard. You have talked so much about so many things that I believe the participants will reflect on that later. One important issue when we talk about reparation is the issue of access to justice. And in the case of the African court, some of the issues that have been raised has to do with the access of citizens and also the civil society organization to take cases to the court, including reparation cases. In addition to that, the African courts and other regional courts like the ECOWAS court has delivered several judgments on issues of reparation. But one of the major challenges that has been raised in literature, Your Excellency, has to do with the issue of implementation, adherence by member states and implementation of these judgments. So probably maybe those might be some of the issues, if time we allow, for you to address. Institutional reform, sub-regional institutional reform is also one issue that you have a recommendation that you have brought to fore. We hope that some of these things will be looked at when you will be responding to some of the questions that will be raised later. Excellencies, distinguished participants, as you must have been aware over the past 2 days, that the African Union declared this year as our year of justice, justice for Africa and the people of African descent through reparation. There is a particular directorate at the African Union called CEDAW. CEDAW is a directorate that is responsible for bridging the gap between the citizens and also the policymakers on the work that the African Union does across the continent. And CEDAW is responsible for this year theme of the year, conceptualization of the project and also implementation. And I'm therefore happy that we have a representative of that department in person of Mr. Koko Agbanewo. He is the program officer at the African Union Citizens and Diaspora Directorate. So, Mr. Koko, you are going to tell us why declaration of this year as the year for justice for African and the people of African descent. What has been done, particularly looking at historical injustices? What has been done? What are the challenges that has been encountered? And what are some of the prospects, recommendations on the way forward for us to be able to address historical injustices on the continent? Over to you.
Merci, Dr. John. Et je suis M. Vincent Humbo. J'ai été détaché depuis 2023, depuis 2022, pardon, au département chargé de la diaspora africaine et des citoyens africains pour appuyer justement le personnel de ce département. Donc, à la demande de ce département, donc mon gouvernement a voulu bien me détacher pour servir de personne d'appui. Alors, je ne sais pas vraiment si je peux encore dire quelque chose parce que le docteur John, dans son mot introductif, aussi bien que le professeur, ont vraiment relaté, ils sont passés en revue le rôle pragmatique et pratique que joue l'Union africaine dans ce processus de la justice transitionnelle, mais aussi dans le cadre du thème de l'année 2025. Alors, je vais précisément revenir sur ce que le département fait et dans le cadre du thème spécifique de l'année 2025, et rappeler qu'il y a trois décennies déjà, en partant de 1992 jusqu'à 1993, et plus proche de nous, 2001, il y a eu beaucoup d'initiatives qui ont été prises, que ce soit par l'Organisation de l'Unité africaine, l'Union africaine. Beaucoup d'initiatives ont été prises dans le cadre justement d'aller à l'encontre des injustices créées tout d'abord par la traite négrière, l'esclavagisme et la colonisation, mais aussi ramener les dirigeants africains à prendre conscience, à réellement prendre conscience de ce processus de réparation, de s'approprier tous les mécanismes mis en place par les chefs d'État et de gouvernement. Parce que quand on parle de l'Union africaine, en réalité, on parle des chefs d'État et de gouvernement qui donnent des recommandations à l'Union africaine, au leadership de la Commission, qui à son tour travaille en tant que s'attelle à fixer les visions données par les chefs d'État et de gouvernement. Et donc, dans le cadre du thème de l'année 2025, qui est justice pour les Africains et les personnes descendantes africaines à travers les réparations, il faut dire qu'on est parti de 2023 à l'issue de la conférence tenue à Accra sur justement la constitution des fronts communs pour soutenir les réparations. Donc, c'est partant de cette conférence qui a été initiée à travers une décision, la décision 847 adoptée par les chefs d'État et de gouvernement. Donc, à l'issue de cette conférence, les experts qui étaient à Accra, les experts invités à travers le monde, j'ai noté la présence des personnes africaines, des Africains d'ascendance africaine, des experts qui soient de la diaspora vivant en Afrique ou ailleurs. Tous ces experts ont été conviés pour réfléchir sur le processus de réparation. Ainsi dit, à l'issue de cette conférence, il a été proposé que l'Union africaine, le continent africain, essaie de prendre une année et réfléchir sur le processus de réparation. D'où l'année 2025 comme année dédiée aux réparations. Alors, pour ne pas empiéter sur ce qui a été dit plus loin, des recommandations ont été faites à travers la décision 884 de 2024 qui recommandait à la Commission de l'Union africaine de collaborer avec les communautés économiques régionales, les REX, et en vue de véhiculer les idées autour de ce thème et dédié à l'année 2025. Alors, des recommandations, il y en a eu. Et je vais parler de 3 recommandations plus spéciales pour moi. Donc, il a été recommandé que les États membres appuient à la mise en place d'un comité des experts sur les réparations. Secondo, la mise en place d'un groupe de référence des experts juridiques. Et en troisième position, de voir la faisabilité et dans quel contexte on pouvait mettre sur pied un fonds d'appui pour les réparations. Alors, à travers des thèmes de référence, ces 3 recommandations ont été adoptées plus récemment à Malabo et la direction, notre département est en pleine réflexion. Le département travaille de commun accord avec les différentes communautés économiques régionales en vue de mettre en place ces différents comités. Et il a été lancé un appel à candidature à travers les doyens régionaux qui sont appelés à envoyer des propositions de candidature en vue du lancement de ces différentes commissions, de ces différents comités d'ici quelques semaines. Alors, pour aller en détail à propos de ces 3 éléments que j'ai cités, il faut dire que l'idée derrière l'installation de ces différents comités est de permettre vraiment que les États membres s'approprient, mettent dans les différents programmes régionaux tout ce qui entoure ce processus de réparation, qu'elle soit nationale, continentale, même au-delà du continent, parce qu'il ne faut pas oublier que l'Afrique, dans la définition qu'a donnée les États membres dans le sens de la Commission, l'Afrique a aujourd'hui 6 régions. Et la 6e région, c'est justement la région qui appartient à la diaspora africaine, qu'elle soit sur le continent africain ou hors du continent. Et donc, le département chargé de la diaspora s'attelle à vraiment mobiliser la diaspora africaine derrière cette cause de réparation, de justice transitionnelle. Et j'échangeais avec un aîné ce matin et qui me donnait un exemple, en tout cas, je crois qu'il est originaire de l'Est du Congo, et qui me parlait du rôle qu'a joué un certain membre de la diaspora pour venir en aide justement et un problème, et pour venir en aide à une communauté qui subissait un problème au niveau de l'Est de la République démocratique du Congo. Et il a juste pointé du doigt le fait que l'intervention de la diaspora issue de la communauté a permis, un temps soit peu, de venir au secours de cette communauté qui était en difficulté. Et donc, nous travaillons à mettre en exergue, à faire voir le rôle primordial que doit jouer la diaspora africaine, mais aussi les personnes d'ascendance africaine. Il ne faut pas oublier que dans certains pays, je prends l'exemple du Ghana, il y a certains membres des Africains d'origine, des Américains d'origine africaine et des Européens qui ont décidé de revenir et prendre les nationalités de leur pays d'origine. Et même revenir s'installer pour contribuer justement au développement non seulement de leur pays, mais aussi au développement du continent. Et donc, il est très primordial que chaque État membre, parce que quand on parle de l'Union africaine, oui, les projecteurs sont toujours sur peut-être le leadership de la Commission. Mais derrière l'Union africaine, c'est les États membres, c'est les chefs d'État et de gouvernement qui dictent leur vision et que la Commission met en pratique. Et donc, tout ce que la Commission fait, surtout comme recommandation, elle le fait en commun accord avec les États membres. Donc, pour moi, parler de la Commission, du rôle de la Commission, c'est parler aussi du rôle que jouent les États membres, que nous représentons tous ici dans cette salle. Alors, pour conclure, monsieur le docteur John, ce que je vais dire justement au niveau des États membres, c'est que il est très, très, très primordial que dans ce processus de réparation, dans ce processus de la justice transitionnelle, que le côté domestique soit privilégié. Que le côté domestique, que le côté national soit privilégié, parce que c'est sur le plan national qu'on peut en réalité détecter faire face à la réalité qui se passe sur le terrain. Et c'est justement les communautés de base, les communautés traditionnelles qui subissent les atrocités, qui subissent toutes les formes d'attaque, que ce soit dans tous les domaines possibles. C'est ces communautés de base qui sont aptes en réalité de révéler tout ce qu'elles traversent comme difficulté. Et c'est aux États membres, aux gouvernants, de s'approprier en réalité toute la vision de la Commission de l'Union africaine. Donc, je vais dire par là, toute la vision des chefs d'État et de gouvernement. Merci.
Thank you very much. Can we give him a round of applause, please? Thank you very much for taking us through the roles of the African Union, particularly in conceptualizing the theme of this year. But as we have heard since yesterday, that the fight for justice for Africa and the people of Africa did not start today. It started a long time ago in the 1980s, when MKO Abiola from Nigeria was one of the pioneer advocates for that. I'm now speaking as African, not necessarily as African Union staff, and we have had series of declarations, proclamations on justice for Africa and the people of African descent. I think we need to begin now to look at practically how do we overcome this challenge of historical injustices. Probably maybe some of the participants that we ask questions will come up with practical recommendations on how to overcome this challenge. In addition to that, we live in a global community where the global system is skewed against the people of Africa. You look at the highest decision, the critical highest decision-making body, the Peace and Security Council of the United Nations, having no representative from Africa. We are talking about justice for Africa and the people of Africa. If you are not sitting at the table, definitely decision will be skewed against you. These are some of the things that we need to critically interrogate. And probably another thing that we also need to look at, the people of African descent, the diaspora, there is what we call the seized organs, the seized regions of the African Union, which is the diaspora. In concrete time, how do we integrate and make these people of diaspora to feel that they are part of the African Union? But by the way, thank you very much. I believe there will be questions for you by the time we open the floor. Now it's now giving me the opportunity now to turn over to the representative of the civil society organization. You will agree with me that civil society organizations, they are very critical in their roles on transitional justice and also on reparation. Some of you may be aware, what we have today as the African Union Transitional Justice Policy, the civil society organization play a critical role through CSVR and so many other organizations across the continent for us to put heads together to be able to accomplish what is now known today as the African Union Transitional Justice Policy. And no wonder the policy is rich in time of provisions. Now, practically speaking, what can be, what should be, beyond advocacy, practically speaking, what should be the roles of the civil society organization in actualizing the objectives of the theme of this year? Over to you, representative of Parliament.
Thank you, Ambassador. All protocols observed. I think many of the speakers before me, Honorable Judge as well before he stepped out, Ambassador and our colleague from CEDAW, have outlined the scope of work that needs to be done in advancing justice for Africans and people of African descent through reparations, particularly in line with the conceptual document of the theme of the year, which defines historical injustices as apartheid, colonialism, and slavery. And so, to respond, and I don't intend to take too much time, I think I'll start off by saying that there are several battles. And I'm using the word battle because nothing about this work is easy whatsoever. I mean, Ambassador was just outlining the inherent inequality in the global political landscape. And so there are several battles to be won in multiple spheres. And there's a battle in the legal sphere, and I think Honorable Judge, before he stepped out, was talking about this a little bit. And you might wonder, how, why? And that is because, particularly, I think international law, in law and in practice, right, with precedent, it is clear that victims of harm, human rights abuses and mass atrocities, the likes of which we saw during the colonial and apartheid regimes on this continent, as well as globally through the transatlantic slavery, are entitled to repair, the right to repair, right? We can all agree on this. But for some reason, this right disappears in both recognition and implementation when we apply it to the African context, right? And what we are having to do and what we are having to see in some of the conversations that we have to engage in is rewriting and re-arguing that Africa's people are human beings, they have dignity, and like any other group in history whose right has been violated, have a right to repair, right? We're starting to have that conversation now, which, leads me to the second battle that needs to happen, which is a battle in the political sphere. And I think Ambassador was just saying that the global political infrastructural system is inherently unequal, right? And I talk to some colleagues and they say, and even the most well-meaning of them in CSO spaces say, oh, well, Ruth, this is a political issue, this reparation stuff. It's really political. And it leaves me wondering, what is political about the right to repair? And I know we've had several conversations, including some of the conversations that have happened on this stage, where we say, in terms of priorities, we have governance issues as Africans, we have corruption, we have impunity, territorial disputes, et cetera, and maybe these should be prioritized over this fight for reparations for historical injustices. And all of these are valid points that we must engage in. But while we are agonizing and bickering amongst ourselves, the wheels of politics, of global politics, are spinning, right? And as a matter of fact, Africa as a continent, we're incredibly late to the conversation. 2025 really is the first time the continent has come together in a coordinated effort at all levels for an extended period of time to talk about reparations for historical injustices, right? We've had summits, we've had forums in the past, we have some declarations to refer to, but this happened at some spark in history and we left it at that. We're building, but for the first time, and I think a lot of it has to do with the fact that the African Union prioritized this issue as the theme of the year. And I think it definitely, it definitely gives maybe a little bit of a cynical meaning to the term African time, because our siblings in the Caribbean are much more advanced in this struggle than we are. And I think Justice earlier in the morning panel was saying something about a study visit to the Caribbean. If we look at the African Americans in the US, in Canada, we look at Haiti, they're much more advanced in this struggle than we are. But that doesn't mean that, all hope is lost, because as late as we are, a lot of action has been happening this year by CSO partners. And so with that being said, what exactly is the role of CSOs in this battle, the legal battle, the political battle, the moral and ethical battle, the systemic battle? So late as we are, I think at this point we are 10 months of engaging with this theme. We know now that reparations for persons of African descent and for Africans for historical injustices is a broad, cross-cutting, multidisciplinary and multidimensional event. It's huge, right? And 1 year is not nearly enough. And one thing that the African Union did during the ministerial summit in July was to extend the theme of the year to the theme of the decade. So now we have a decade-long time between starting 2026 to 2036 for action on reparative justice. So here we are, we have 10 years to move this agenda forward. We've never had this before. What can we do? The Abuja Proclamation and the Accra Declaration, two central continental instruments on this issue, identifies very clearly the role of CSOs as engagement and fostering engagement, direct engagement with affected communities, victims, and people, both on the continent and in the diaspora, the sixth region. And transitional justice experts would agree with me that TJ processes are graded by how much victim-centeredness they incorporate, right? We can't just sit in a room like this and decide what reparations is for Africans and people of African descent and run with it. We must engage with citizens. And so on this agenda, CSOs are most central in engaging individuals and people on the Pan-African reparations agenda. And I use the term Pan-African because it means that we're engaging on the continent as well as in the diaspora. And some of the ways in which this can happen and has been happening is citizen-to-citizen engagement, including awareness raising, right-based education, deconstruction of technical language, when we use technical language to describe some of the things. I mean, legalese is something that, many people will not understand, but some of these documents are in legalese. And so the deconstruction of these documents so that our grandmothers and grandfathers can understand them is a big thing that CSOs are supposed to be doing and are doing. Gathering community perspectives on perception, community perspectives on reparative justice, engaging with movement accountability sessions, bringing people together and having that kind of conversation. So citizen-to-citizen engagement is something that CSOs can do. And an example of this being done, I mean, there's several events that have happened in the past, but upcoming one in Nairobi is the Pan-African Reparations Festival, Wakati Wetu Festival, which is bringing people from the diaspora as well as the continent together to have a conversation, a multi-dimensional conversation on this issue. So that's one type of CSO fostering of direct engagement, citizen-to-citizen engagement. A second one would be citizen-to-institutional engagement. And this means essentially bridging the gap between communities and the national, regional, and continental levels for action. We talk about our national governments, our RECs, the African Union and its specialized agencies and bodies and organs, who all have a role to play, identified within the conceptual framing of the theme of the year on this issue in fostering reparations. And so, for instance, stuff like the Global Reparations Fund that our colleague from CEDAW was just speaking about, the AU Envoy of Reparations, which, happy to report that has been confirmed as President John Mahama of Ghana. And recently they passed the terms of reference for the legal committee of experts on these institutions and on these frameworks with the implementation of the same. A third one would be fostering transcontinental engagement and partnerships. And so we talk a lot about the sixth region, right? And I mean, just taking stock of the room right now, the theme is justice for Africans and people of African descent through reparations. I wonder how many people in the room are from the African diaspora. And so in working this year, in 10 months of CNSO engagement, we realized that there's a huge gap in incorporating diaspora perspectives in our systems on the continent. And this is not the case. This is not what was said in the Abuja Declaration, Abuja Proclamation. This was not what was said in the Accra Declaration. This was not what was said in the conceptual framing document of the theme of the year. So that is a gap that exists that CSO can bridge with continued engagement with other CSOs in the African diaspora. A fourth one would be bridging global and continental arenas. So CSO engagement at the UN General Assembly. I think the General Assembly just happened. A bunch of CSO partners were having side events, trying to engage these country representatives to the UN, trying to engage other international CSOs to mobilize action and for solidarity movement for promoting reparations. UNESCO General Assembly is coming up at the end of November. We're planning to do a bunch of activities on the sidelines to talk about restitution of African cultural heritage. So bridging those spaces and taking African community perspectives into those spaces is also an important role. Lastly, will be watchdogs, right? Before we forget this continent, I think we have a collective attention span deficit. We have a collective attention span of a goldfish. We pick an issue, if it's climate, and we go for it for 1 year and then we drop it. And so in order to ensure that this doesn't repeat itself again, and when we pick up the issue of reparations, we don't end up dropping it again and lose the momentum we've gained in this 1 year. Continued action, continued orbiting of the African Union system, continued orbiting of our government, continued engagement with our RECs is something that definitely must happen, and it's an opportunity for CSO partners to, again, bring in community engagement into those spaces. Thank you.
Thank you very much for that excellent intervention. Let me recognize His Excellency Kabuya, the Minister for Human Rights in DRC. You are welcome, sir. Excellencies, distinguished participants, ladies and gentlemen, you will agree with me that the representative of the civil society has raised so many critical points. The first one, which is very important, is the continuity of advocacy that the civil society is currently engaging in. And also, very interesting to note, that the theme of this year, the Assembly of Head of State and Government of the African Union, has now made a decision that it should be declared a decade agenda. So over the next 10 years, our focus at the African Union, together with other stakeholders, we will continue to work on the theme of this year. And so the second point, which she also emphasized, has to do with the right to reparation. That reparation is not just a word, it's not just an advocacy. It is the right of the victim to have access to reparation. And those are some of the things that need to shape our strategy on reparation agenda in time of advocacy. She also emphasized the need for us to stop agonizing and begin to organize, which is also another fundamental role of the civil society organization, which we need to take into consideration. Unfortunately, Professor, one of the judges of the African court, has just left. Issues that we need to raise is the practicality of this agenda. How do African judicial system take this case forward? Can we test it at the international judicial system level? Can we take the case of these historical injustices to International Criminal Court to test the reliability of this agenda? Those are some of the things that we need to look at in practical terms. The other important point that we also need to emphasize, unfortunately the professor has also left, is the role of the academia. One thing in the academics is that if you don't tell your stories, another scholar will tell it differently in the way it suits him or her. And this is where the African scholars need to arise to the challenges before us. We need to document the historical injustices. We also need to have our own archives, intellectual archives and documentation. And this is what I see as one of the critical roles of the academia in our participants. I believe it will be an opportunity to also tell us what the regional economic community and regional mechanism have been playing in this particular area of reparation. Without much ado, I want to say a big thank you to the panelists. I'm now going to open the floor for comments, for questions. And please, I want us to be as practical as possible so that this year, the theme of this year will not just come and go, but for us to be able to take back home, concrete recommendation that we can pursue at the end of this forum. So I now open up the floor for questions and comments. I see the first question from here. No, you will be number one. You'll be number two, the woman here on this table. Then number three. Number four. Okay, and Professor Mutoe, number five. Over to you.
Thank you very much. My name is Johannes from Namibia. Unfortunately, our honorable, on Tuesday, 7th of October in Namibia, I'm talking now on the case that the Nama and the Overherero is requesting or demanding reparations from Germany. And on Tuesday, the 7th of October, we are going to ask the Namibian High Court to make a declaration that actually Germany committed genocide 121 years ago, 1, 2, and then to pay reparations directly to the communities. Now, in this case, our lawyers is going to argue that Germany is not going to be protected by state immunity through different international conventions and treaties, that Germany, because it has committed the crime on the Namibian soil 121 years ago. They came, colonized, took our land, killed our people, and actually issue extermination order that the Nama and the Ovahero has to be wiped out from the face of the earth. And because of that, and you know, earlier listening to some of the legal people, in terms of the customary international law, the crime is committed on the Namibian shore. And mind you, when they came 121 years ago, our people were not living in a wilderness. They were having their customary law. So they came and they imposed their Eurocentric, racial, whatever demonistic international law on us, and used that law and being protected today by that law and to take whatever they have. Now our lawyers are going to ask the Namibian High Court that Germany should come and stand trial into the Namibian High Court. Obviously, it will be a very complicated case. Now, what I wanted to put, and I hope, John, you will put it to and find a way for us to get the responses through the African court. How can we take this matter further through the African court? Because it will mean that we are taking a international state to court, first trying in Namibia, Africa, and then we know how it's end up in ICJ. That will take 20, 30 years. Number two, you talked, John, about the Peace Fund. Communities like ours and other victim communities, how can we access this? Is it only through member states? And if we only go through member states, you know how it goes. It never comes and we never have the opportunity. To the CEDAW, you were talking about the process and everything. Again, how is the communities going to have access to those facilities and processes that you offer? I think with the civil society, we are happy because with these opportunities that there is, we can continue our advocacy work and try to put pressure on these countries. And I'm talking more from a restorative justice. I know we talk more transitional justice here, but I'm talking more restorative justice of crimes that happened when the colonialists came and took our land. And because of that, this is why we are still poor, marginalized, and we cannot make our own decisions. Thank you.
Thank you very much. I hope we have a representative of the women. We want everybody to be included in this discussion. We go like this, yes, second.
Merci pour la parole. C'est l'honorable Ronald Kisamba. Premièrement, la vérité. La vérité est la première de réparation. Nous, en tant que Congolais, nous exigeons que la lumière soit faite une fois pour toutes. La vérité sur le rôle des puissances régionales et internationales sur les réseaux économiques qui financent la terreur, sur la chaîne de complicité qui permet à ce carnage de se perpétuer ici dans notre pays. L'Union africaine, comment est-ce qu'elle pense nous accompagner pour que nous puissions enfin arriver à la reconnaissance du génocide en République démocratique du Congo? Parce que nous, les députés, nous avons travaillé en intelligence avec le ministre national des droits humains pour que nous puissions lancer une pétition au niveau national à Uvira, à Beni, à Bunia, là où il y a eu des crimes de guerre et à Kisangani. comment est-ce que l'Union africaine pense nous accompagner pour la reconnaissance du génocide congolais. Merci.
Thank you very much. Yes, madame.
Merci pour la parole. Je suis Madame Kadjour Jean d'Arc. Je suis membre de la société civile. Merci pour le thème choisi par l'Union africaine qui parle des réparations, de la justice transitionnelle. Nous avons suivi depuis l'ouverture et jusqu'ici, je suivi les panélistes. Je voulais épingler une chose par rapport aux réparations. Nous savons tous que les réparations sont très nécessaires pour les victimes car ça permet de les soulager. Mais ma question peut paraître un peu bizarre, mais elle a sa place. Qu'est-ce que vous faites? Est-ce qu'il n'y a pas aujourd'hui, en cette année, parce qu'il y a des populations qui ont besoin d'être soulagées par toutes les formes de réparation possibles. Mais est-ce qu'il n'y a pas moyen de prévenir les réparations? Qu'est-ce que je vais dire par là? Je suppose que c'est important au niveau de l'Union africaine de s'attaquer plutôt aux causes qui produisent les réparations. C'est bien de réparer maintenant, mais devons-nous, depuis que je suis toute petite, moi je suis de l'Est, j'ai subi des atrocités jusqu'à abandonner le coin qui nous a vu grandir et aujourd'hui nous retrouver. C'est vrai que nous sommes en RDC, mais on aimerait être en calme, on aimerait être chez nous calmement pour que nous ne puissions pas nous tous nous retrouver ici coincés à Kinshasa. Mais qu'est-ce qui est fait au niveau de l'Union africaine pour qu'on prévienne les réparations? Ce qui est déjà fait, oui, il faut réparer, mais qu'est-ce qui a produit ces réparations-là? Nous parlons de la guerre, nous parlons d'autres choses, mais qu'est-ce qui doit être fait? Je pense que ça devait être le focus de l'Union africaine, s'attaquer à la racine. Qu'est-ce qui fait que nous réparions? C'est la guerre. Qu'est-ce qui fait qu'on parle des réparations ci et là, en RDC? Oui, les réparations, mais pensez-vous, est-ce que ces réparations sont d'abord durables? Aujourd'hui, réparation, oui. Vous avez parlé de fonds, un fonds qui doit être créé ou bien qui est déjà créé. Est-ce qu'il n'y a pas des gens qui vont utiliser ce fonds pour leurs gains personnels et au lieu que ce fonds soit destiné aux victimes, remplissent les poches de certaines organisations? Ça, c'est un. Alors, je pense que le plus important au niveau de l'Union africaine, c'est de s'attaquer à la racine qui produisent les réparations et les déraciner. Merci.
Thank you.
Merci. Je m'appelle Jean-Baptiste Ditaba. Je suis membre de la société civile africaine au sein de la structure consortium panafricain pour la paix. Je vais pratiquement rejoindre mes deux prédécesseurs pour poser une question toute simple. En ce qui concerne, par exemple, je vais prendre l'exemple de la RDC, où l'actuel président américain, depuis qu'il a appris que ce qui se passe à l'est de la RDC a déjà fait des millions de victimes, plus de 7 millions. Il est tellement choqué qu'il en parle partout. Il attaque même les Européens et dit « Mais ce qui s'est passé en RDC, vous étiez au courant, vous n'avez rien fait. » Et ce qui se passe à Gaza, en Ukraine, c'est tout le monde qui en parle. En Europe, aux États-Unis, dans des sommets internationaux. Mais qu'est-ce qui fait qu'en Afrique, où certaines atrocités se passent de manière totalement inouïe, les Africains sont calmes, incapables de donner de la voix? Puisque aujourd'hui, nous parlons de la justice transitionnelle. Parler de la justice transitionnelle, c'est d'abord reconnaître qu'il y a eu une injustice. Qu'est-ce qui fait que les Africains, au niveau de l'Union africaine, on n'arrive pas à reconnaître les injustices qui se passent au sein même des peuples africains et pour finir par parler de la justice transitionnelle? Merci.
Yes, somebody at the back. I could see some hands at the back.
Thank you very much.
My name is Joseph Sina. I'm a member of the African Committee of Experts on the Rights and Welfare of the Child. Mine is more of addendum to the presentation just done. As you all know, the African Committee of Experts is a treaty body of African Union mandated to implement, monitor the implementation of the Charter, African Charter on the Rights and Welfare of the Child. And in that charter, it mandates the committee to monitor, also investigate cases of violation, and also to consider communications and complaints from member states. So for us, we consider reparation as essential remedy to addressing issues of violations in post-conflict and also transitional justice. So we think reparation should be child-sensitive, focused, and also be done in the best interest of the child. And that is why we think it goes through the process, it focuses on rehabilitation and also protective mechanisms to ensure that their fundamental rights are protected and adhered to. So we are in the process of developing a guideline that is consistent with all the regional instruments and also international standards, so that we make sure that member states comply to those issues in addressing violations reported by children. And this is what I just want to share with you.
Thank you very much. I think we only have one more hand remain. We take that and then conclude at the back.
Merci beaucoup pour la question. Je m'appelle Dominique Lofico. Je suis écrivain. Ma question serait d'une importance un peu capitale parce que j'ai vu une forme de négligence sur un point. La négligence est qu'on a oublié de parler sur un fait psychologique en matière de la violence sexuelle. Beaucoup de gens, beaucoup d'intervenants ont pu parler sur la justice transitionnelle. Je veux qu'il n'y a que des juridictions. Alors, ma question coulera sur plusieurs volets dont j'aimerais préciser un point. Avant de poser ma question, j'aimerais dire, quand la femme est victime d'une violence sexuelle et que la personne qui a violé la femme, c'est-à-dire l'abuseur qui a violé la femme, n'est pas là, l'acte sur le fait psychologique va endommager et la maladie va continuer. Raison pour laquelle j'aimerais dire qu'au lieu de parler de la justice transitionnelle, et pourquoi pas y rajouter sur la psychologie transitionnelle. Parce que dans 80% des problèmes de la femme qui est victime de la violence sexuelle, c'est la psychologie qui est endommagée, qui prend toute la place. Ma question est, pour clôturer, quelle est la distinction que vous faites? Quel est le plus important de point entre la psychologie de la personne qui est abusée sexuellement et la justice transitionnelle dont il se pourrait que l'abuseur n'est pas là et que l'acte psychologique soit endommagé? Merci beaucoup.
Okay, can you come now? I think we have come to the... Now, because of time, I'm going to turn to the panelists. There are so many questions that have been asked. Some of them comment. We might, if the time permits, we might still take the second round of questions. But I will just open the floor to the panelists for them to respond to the questions that are relevant to them.
Ok, merci, docteur. Je crois que la première question, en réalité, c'est un commentaire, non? C'était un commentaire, votre réaction, s'il vous plaît.
No, I mean, the questions that have been asked to just...
Yes. Yeah. Votre première question, votre première réaction, il s'agissait d'un commentaire ou bien c'était une question que vous posiez, s'il vous plaît? Ok. Alors, pour revenir à votre question, en réalité, hier, ça a été passé en revue dans les différents panels. Vous-même, vous aviez évoqué différents aspects de cette question. Mais moi, ce que je peux dire dans ce sens, c'est que vous-même, vous avez en quelque sorte ouvert une brèche de solution par rapport à votre question, étant donné que malheureusement le professeur n'est pas avec nous. On a abordé le cas de la Cour africaine de justice. Et la question était de savoir comment la Commission, l'Union africaine, peut aider, peut intervenir dans le cas namibien par rapport à l'ancienne puissance qu'est l'Allemagne. Il faut dire qu'à travers les différents partenariats existants entre ces grandes puissances et la Commission de l'Union africaine, il y a des différents processus qui sont suivis. Et par exemple, je m'en vais vous parler de la coopération, justement dans le cadre de la justice transitionnelle, qui existe entre la Commission et l'Union européenne d'une manière générale. Et je ne vais pas prendre le pays individuellement parlant, je vais parler dans un ensemble, et pour dire que nous travaillons, quand je parle de nous, pas nécessairement le département auquel j'appartiens, mais la Commission travaille d'arrache-pied pour essayer de trouver des solutions par rapport à votre question. Donc, concrètement parlant, qu'est-ce que la Commission fait dans ce sens? Je crois que le docteur John avait parlé de ce cas dans son introduction, où il a listé les différents mécanismes, les différentes initiatives qui sont mises en place justement dans le cadre de l'accompagnement de ces différents pays, dans le cadre de l'accompagnement des différents cas remontés au niveau de la Commission. Parlons du Fonds de la paix. Et je crois que le docteur John aussi est bien placé pour revenir à cette question parce qu'il avait passé en revue ces différents mécanismes. Donc, comment les communautés à la base peuvent avoir accès à ces fonds de la paix. Il faut dire que la Commission, comme on l'avait dit, travaille en commun accord, en collaboration avec les communautés économiques régionales. Et ces communautés économiques régionales transmettent, ils servent de pont entre les pays respectifs, les États membres et la Commission. Donc, toutes les initiatives prises dans le cadre du Fonds de la paix, ces mécanismes sont mis en œuvre directement en collaboration avec les États en question, les États concernés. Et donc, la question est de savoir, en réalité, pour moi, la question est de savoir si les États concernés sont vraiment en harmonie avec les communautés à la base. D'appropriation sur le plan national en vue de véhiculer, en vue de faire, de dispatcher, j'allais dire, tout ce que l'Union africaine, tout ce qui se fait dans un cadre multilatéral ou bilatéral, justement dans le cadre des réparations, de dispatching des fonds pour la paix. Maintenant, et parlant de... Il y a l'honorable Ronald qui est intervenu sur le financement des crimes en République démocratique du Congo et pourquoi l'Union africaine traîne à faire en sorte que l'humanité puisse reconnaître les atrocités qu'on observe en République démocratique du Congo comme étant des crimes contre l'humanité. Mais il faut dire que depuis 2014, à travers le protocole de Malabo, les chefs d'État et de gouvernement ont adopté des décisions justement pour qualifier le colonialisme, l'esclavage et toutes les sortes de crimes commis à travers les pays qui traversent des conflits. Un protocole a été adopté justement pour reconnaître, sur le plan, pour reconnaître officiellement les crimes qui ont été commis depuis le colonialisme et la colonisation jusqu'à aujourd'hui. Mais le problème, c'est le problème de ratification. Les États membres eux-mêmes qui prennent ces décisions peinent à ratifier ces protocoles pour permettre leur mise en application. Secondo, tout récemment, en février 2025, à travers une proposition de la République togolaise, les chefs d'État et de gouvernement de la Commission de l'Union africaine ont aussi adopté à travers la décision 934 de février 2025 une autre décision qualifiant l'esclavage, le colonialisme, le crime contre l'humanité comme génocide. Et donc, en réalité, il y a des mécanismes qui sont mis en place, mais le problème, c'est la ratification. Okay. Pour finir, il y a M. Kadjou de la société civile qui est revenu sur comment l'Union africaine s'attelle à promouvoir les réparations. Qu'est-ce que l'Union africaine... Pourquoi l'Union africaine ne s'attaque-t-elle pas aux causes qui conduisent à la réparation? Et en prenant précisément le cas de la RDC, j'ai eu le temps d'échanger hier longuement avec beaucoup de gens. Et ça, j'ouvre une parenthèse, j'avoue que le premier jour, après la visite du mémorial, j'avoue que j'ai eu beaucoup de peine. Mais pour revenir à sa question, je ne sais pas s'il faut dire que l'Union africaine peine. Oui, pratiquement parlant, on peut dire que les actions de l'Union africaine ne sont pas visibles. Ce ne sont pas des actions qui sont visibles, mais on peut non plus dire que l'Union africaine ne mène pas des actions. Et je l'ai dit tantôt qu'il y a déjà 3 décennies où l'Union africaine s'attelle à toujours parler des procédures de réparation dans ces différentes initiatives. Et il faut noter que depuis 2012, après la conférence de Johannesburg qui a réuni le premier sommet de la diaspora africaine, il a été recommandé aux États membres d'inclure dans leurs les différentes actions sur les plans nationaux le problème de réparation, mais aussi l'engagement, la mobilisation des diasporas africaines dans les différents domaines, que ce soit sécuritaire, dans tous les domaines, d'inclure le thème de réparation dans tous les programmes stratégiques sur les plans nationaux. Bon, je ne sais pas si je peux continuer ou bien. OK. Maintenant, il y a M. Jean-Baptiste qui est revenu sur le rôle joué par le président américain en République démocratique du Congo. Je pense que je ne suis pas du département paix et sécurité, je suis du département qui travaille uniquement avec la diaspora africaine et qui est chargé de justement mettre en œuvre le thème de l'année 2025. Et je suis désolé vraiment que je ne peux pas répondre concrètement, lui donner une solution par rapport à cette question. Merci.
Thank you very much. I think we need to move fast. We don't want to violate the rights to food of the minister and also all the participants. So we'll make it very fast. Over to you.
Yes, thank you very much for your question. I'm just going to go really quickly. I think, Johannes, to your question. So I'm not the honorable judge, but I do work for the Pan-African Lawyers Union, PALU, and we do a lot of litigation at the African Court, as well as engagement with the African Commission for Human and People's Rights. So to answer very quickly your question, one, yes, you can assess, the Namibian people can assess the African Court on Human and People's Rights after they've engaged exhaustively with their national courts and national court systems. And so that is why the process currently with the High Court is incredibly important, because it provides a foundation, and in terms of case building, it gives us precedent and track record to rely on when we in fact get to the point when we engage the African Court. Now, the limitations to that is that the African Court, being a creation of African Union, is not binding on non-state parties to the African Union system. And so in this particular case, we would have incredible difficulty getting Germany to sit at the African Court, because it is not a state party to the African Court system. What might be okay to suggest might be an interstate or state-state dispute at an institution like the ICJ. Example, the South Africa versus the State of Israel case. So that's an interstate dispute, and multiple interstate disputes at an institution like the ICJ, the decision of which would be binding on the parties to the dispute. Now, that's a very basic, fundamental international law response. But some of the conversations that we've been having, and I think Honorable George was saying this as well, is international law in and of itself, what we know of, has limitations. But then there's also something called African international law, which is international law that is created for Africans by Africans. Now, that gives room for innovation and innovative legal approaches to some of the limitations that you might encounter with international law. So we will continue to engage, as you said, and I mean, hopefully we would find some solutions to these limitations that exist. And good luck on the 7th. We're planning to be there as PALU to observe, so I'll be seeing you. I think a central theme, I'm turning now to my second response, so I think a central theme that I found between the questions that was being asked by our Congolese colleagues in the room was the tension between ongoing atrocities and historical injustices. And I think for this, I'll just very quickly structure my answers to institutional limitations and like an institutional technical response and a substantive response. Now, an institutional and practical response is exactly what my colleague was saying here from CEDAW, that the African Union system is not linear. It has multiple departments and multiple frameworks for responding to the different issues that face the continent. So what might be most relevant to the context of, unrest and pursuing peace on the continent might be the African Union peace and security and governance architecture, which is very different from the reparations and transitional justice architecture. And organizations like African Union bodies like AU ECOSOC does a lot of work in breaking this down, because it's a lot of moving parts, right? Breaking this down for citizens and for CSOs to engage. And this is some of the things I was talking about earlier in the role of CSOs in engaging the populations and educating them on rights and appropriate responses when those rights have been violated. Substantively, I think it's also important to not zoom in too much on the phrase historical injustice, right? So because we say historical injustice doesn't mean it ended when we gained independence in the 1960s. We must also understand that it is historical injustices and their legacies. And you might find that almost every conflict on this continent is directly linked to the bad governance that were as a result of colonialism and apartheid. And so when you start viewing it that way, you see these harms and these injustices as an ongoing situation, right? It started way back centuries ago, and it is continuing today. And so when we talk about reparations for historical injustices and their continuing legacies, we find that some of the things we're discussing here are also directly relevant within this context and within ongoing situations. I think, lastly, there was, I think, I'm just going to respond very quickly to a question that came, I think a question that came from the back, and that is, how do we conceptualize psychological, healing in this? And I think earlier in my presentation I mentioned the Abuja Proclamation, which actually defines, the fight for reparations for Africans and persons of African descent, and I quote, as a psychological and political experience. So that recognizes that a lot of the injustices, including crimes that happened on the bodies of African men and women, when we talk about sexual and gender-based violence that happened during those times, recognizing that type of healing and that kind of psychological support is necessary for the African reparations agenda. And so institutions like the Wakati Way to festival that I just mentioned that will be happening in Nairobi has a whole segment on healing and psychological development for victims, generational trauma, and that type of stuff. And for that segment, we would be having yoga instructors, people who can, spiritual guides, and mental health coaches that can help people come to terms with the psychological trauma and generational trauma that were as a result of some of these historical injustices. I think I'll just leave it there. Thank you.
Thank you very much for those responses. Excellencies, distinguished participants, ladies and gentlemen, I think we may want to stop it now so that we round it up for us to be able to go into the closing section. But having said that, over the discussion we have been having for the past 3 days, it is obvious that reparation has two dimensions. One, we have the historical violation of human rights and reparation, which the theme of this year is focusing on. We also have the contemporary violation of human rights and reparation. And it is a collective responsibility that we all work towards reparation of the historical injustices. But the responsibility also lies on the African member states and all of us for us to prevent contemporary violations of human rights that demands justice and reparation on our continent. As we continue, it is a collective responsibility and we all have a role to play. The second point, which is also a question from my brother from Namibia, testing reparation at the national level against the international crime. I think this is a testing of the system, court system in Namibia. I think what Namibia can do is to approach the African court and the African Union Office of Legal Counsel to provide technical support to Namibia on how to take it up internationally. And this is not new, because the African Union provided technical support to Kenya when it was having a case at the International Criminal Court. So I think one of the ways through which we can approach that is for the governments and the people of Namibia to also approach the African Union Office of the Legal Counsel and African Court for technical assistance. The second point, which is also very important, is the need for reform of the African's judicial system and to make them fit for purpose. Access to justice and other limitations that are currently there can then be overcome as a result of this reform. Then my sister has talked so much to the representative of PALU of different dimensions to advocacy of the civil society organization. Unfortunately, we still have a decade to go in this regard. And so the civil society and also the academia has to put effort together for us to be able to overcome this challenge, historical injustices. Somebody asked the question of African Peace Fund. How is this peace fund established and how can member states assess them? Let me just quickly give us a brief example of what we have been doing with the peace fund in recent time. Currently, we are in Liberia, refurbishing one of the primary schools in Liberia. And my colleague from the PCRD reported on this. So one of the things that we try to do is also to address the issue of reparation. And what we are trying to do is to repair the education system in some of our member states, particularly in Liberia, so that the children can have access, those that have been deprived can have access to studies and education. Not only that, African Union we also supported victims of Boko Haram in Nigeria, particularly the women in northeastern Nigeria from the Peace Fund. Thousands of sewing machines and also other materials were provided for the women that are victims of Boko Haram in Nigeria. And capacity building were carried out for them to enhance their capacity economically. So these are some of the things that we do in time of reparation with the Peace Fund at the African Union. So what Namibia can also do is to officially communicate and write for support in particular areas of reparation that you know that the Peace Fund can be utilized, and African Union will respond to that. The other issue that was raised is that African Union should attack the cause of atrocity and reparation. Well, let me also emphasize it, and I'm happy that the Minister for Human Rights is here. The primary responsibility for promotion of good governance is the member states. The African Union can only encourage its member states and provide technical support to member states, but the onus lies on member states. And this is where we have to take the bull by the horns by holding our leadership accountable, our elected officials, government officials. It is also the responsibility of all of us to hold them accountable and also make them fit for purpose to stop violation of human rights in contemporary Africa. This is a collective responsibility, and we have a role to play in this regard. Somebody also asked the question of mental health and psychosocial support. If you were here yesterday, there was a section that was devoted to that. We may not have it as a provision in the African Union Transitional Justice Policy, but we are also working with different partners. A good example in this regard is together with the CSVR and African Union, where we second an MHPSS, mental health and psychosocial support, to South Sudan to provide technical support in that regard. We intend to do that. When the AU envoy on prevention of genocide and crime and atrocity visited Goma, one of our plans was also to recruit a mental health and psychosocial support to provide mental health and psychosocial support to the victim of human rights violation in Goma. So these are some of the things that I can respond to, but without much ado for us to be able to close this section, I just want to conclude this section with one statement. And that statement says, reparation for historical and contemporary injustices is a collective responsibility. Let all of us, therefore, join hands together to overcome the challenge of injustices in Africa. This is the only way we can overcome historical and contemporary injustices as the way forward, so that by the time we come here next year or in 2 years' time, we are not discussing the same issue. On this note, I want to thank you for attention, and I want you to join me in giving a good round of applause to the panelists for the job that has been done. Thank you very much for your attention. I believe that the next section, which is going to be the closing ceremony, will not take too much time, as we want you to also go to the town and also boost the economy of DRC with your limited DSA. Thank you so much for your attention, and looking forward to see more of you participation in reparation program across the continent. Thank you.
Merci beaucoup, Dr. John Ikubaje. Merci aux panélistes. Nous arrivons maintenant à la fin de ces travaux de la 9e édition du Forum africain sur la justice transitionnelle. Excellences, Monsieur le ministre des Droits humains, Excellences, Monsieur le Président de la Commission nationale des droits de l'homme, Monsieur le coordonnateur de la CIAVAR, distingués participants, chers experts, membres du corps diplomatique, permettez-moi de rendre le tablier et d'inviter sous vos applaudissements Madame Guylaine Matabaro, qui va conduire la cérémonie officielle de clôture. Je vous remercie.
Avant de commencer cette session de clôture officielle, Excellences, Monsieur le ministre des Droits humains, Mesdames, Messieurs, en vos titres et qualités, chers participants, je tiens encore à souhaiter la bienvenue en RDC, en République démocratique du Congo, terre d'hospitalité et de résilience, à tous nos frères et sœurs venus de pays d'Afrique et d'ailleurs. C'est l'occasion ici d'exprimer notre profonde gratitude à la Commission de l'Union africaine, à ses experts, ainsi qu'à tous les partenaires et amis qui, par leur engagement et leur foi dans la justice, ont permis la réalisation de ce forum. Ce parcours fut très long, exigeant, mais chaque étape franchie a renforcé en nous le sens des responsabilités collectives. Pour illustrer ce chemin, j'ose emprunter l'image de la maternité, tel un projet que l'on porte 9 mois. Les femmes comprendront mieux. Entre incertitude et espoir, jusqu'à la naissance tant attendue. Ce forum, fruit d'une conception partagée et de multiples efforts, est aujourd'hui cet enfant que nous plaçons entre vos mains. Et comme en Afrique, l'enfant n'appartient pas seulement à ses parents biologiques, mais à la société, les échanges et recommandations issus de ce forum sont légués à la République démocratique du Congo, à toutes nos sociétés, et ce, à travers vous, chers participants. Je salue toutes celles et ceux qui ont accepté notre invitation et qui ont enrichi les débats. Recevez ici toute la chaleur de notre accueil et l'expression de nos meilleurs vœux. Votre présence rend ce rendez-vous plus grand, plus riche et plus porteur d'espoir. Que cet esprit de gratitude, de partage et de solidarité marque à jamais l'empreinte de ce forum historique. Merci donc à chacun d'entre vous pour votre engagement, pour vos idées et votre volonté de bâtir ensemble un avenir de justice et de paix. Je suis Guylaine Matabaro, coordonnatrice du Programme national pour la promotion et la vulgarisation des droits de l'homme en République démocratique du Congo. Et dans le cadre de ce forum, je suis vice-présidente du comité interinstitutionnel pour l'organisation du Forum africain sur la justice transitionnelle. Et donc, sans plus tarder, j'invite le représentant du CSVR pour son mot de clôture.
Good afternoon. Please allow me to stand on all protocols already observed. Excellencies, distinguished delegates, esteemed colleagues, it is my pleasure to deliver the closing remarks on behalf of the Center for the Study of Violence and Reconciliation. As we bring the 9th Transitional Justice Forum to a close here in Kinshasa, it is fitting to reflect on the remarkable ground that we have covered over these past 3 days. We have engaged in rich and candid dialogue under the theme Justice for Africans and People of African Descent through Reparations. Together, we have examined the state of transitional justice and where we are as a continent on issues of reparations. We have highlighted the challenges that we collectively face in realizing reparations for communities and individuals who have undergone suffering and harm on the African continent. We have also highlighted opportunities that exist for our collective effort and call to action for realization of transformative reparations as we need them on the continent. Several important outcomes have emerged from the deliberations. For one, we acknowledge that reparations are not charity. They are justice that is owed to us as Africans. We cannot build lasting peace in Africa while ignoring the debts of history and the structural harms that continue to shape our present. We have also established that reparations are central to justice and peace. They are indispensable for restoring dignity and building trust between states and their citizens. We have also acknowledged our history and the importance of our history in shaping the future. We confronted, amongst other things, the legacies of colonialism, slavery, and historical injustices, and we agreed in this meeting that reparations must address both the past and its enduring consequences in the present. We established also that women and youth are not participants on the margins when it comes to transitional justice and reparations, but they are central as leaders of this agenda. Their voices, therefore, must not only be heard, but must shape the very design and reparative policies and practices. We have heard from speakers and experts in the room that their perspectives strengthen the legitimacy and sustainability of our efforts. We also underscored the importance of reparations as healing. Beyond material measures, we underlined the importance of symbolic, psychosocial, spiritual, traditional, and community-based initiatives that restore dignity and enable societies to heal. We also emphasized as a collective the importance of partnerships and accountability. We committed, amongst other things, to strengthening collaboration between the African Union, the regional economic communities, the African Union organs with a mandate on reparations and justice, national governments, civil society actors, the academia, and the international community. These partnerships are not only central, but are critical for us moving the agenda on reparations forward. And we are grateful to the African Union for extending the tenure of the African Union theme of the year that focuses on reparations for Africans and of people of African descent. As a 10-year agenda, we have a lot of ground to cover, and this forum therefore really gives us a starting point towards formulating, reimagining, and developing action plans, actionable and critical steps towards realizing reparations for those to whom they matter the most. This forum, therefore, has given us tools, strategies, and a powerful outcome document. But more than that, it has given us renewed conviction that reparations are not an aspiration for tomorrow, They are an imperative for today. The forum has also reminded us that reparations are not simply a policy choice, but a moral and political imperative. They're an investment in peace, reconciliation, and a more just future for Africa and its people. On behalf of the Center for the Study of Violence and Reconciliation, we extend our deep appreciation to the government and people of the Democratic Republic of Congo for their hospitality. As a meat lover myself, I've been in meat heaven for the past 3 days, and I've really enjoyed the assortment of meats that have been made available to us, and the very rich food and the culture that we have been exposed to during the past 3 days of the TJ Forum. We thank you also for your example of resilience in the face of deep historical and ongoing injustices. I would like to also extend our gratitude to our partners. We extend our gratitude to our partner, our long-standing partner, the African Union Commission, particularly the Transitional Justice Unit within the Department of Political Affairs, Peace and Security. We have journeyed together since 2011 for the past 23 or so years, first and foremost in developing the African Union Transitional Justice Policy, and in also establishing this platform that brings together multiple stakeholders to probe the state of transitional justice in Africa. And when we look back at some of what we have achieved together, the evidence and the impact of such platforms and the partnership we've had with the African Union is self-evident. We have improved practice, we have documented our own African experiences, we have shared best practices and innovation, and as we continue journeying together, we really appreciate the warmness and the warmth that this partnership has brought, the warmth that has extended beyond just CSVR, but has also warmed the continent as a whole in terms of transitional justice and what next needs to be done to advance the implementation of transitional justice on the continent. I would like to also express our gratitude to our funders. As we all know, such an agenda will really require resources, and they've really come to the party time and again in funding this important platform, the convening as we have had in the past 3 days. Amongst us, we have the European Union advancing transitional justice in Africa through the Initiative for Transitional Justice in Africa, led by ICTJ. We have ECAS, who have also funded this convening since 2022. We have also open society foundations that have also contributed that have also supported this convening. We have Impunity Watch, our long-standing partner, particularly in our work with the youth, ensuring meaningful participation of youth in transitional justice on the continent. We have the UNDP that has also funded some of the items in the budget towards making this convening a success. We are grateful again to the Democratic Republic of Congo for covering some of the budget items and for the waiver on some of the costs that would have led to the increasing costs of this Transitional Justice Forum. We are also grateful to our partners from civil society, the academia, African Union organs, the regional economic communities, victim networks, researchers, research institutes, and think tanks, amongst others, all participants of the Transitional Justice Forum. Without your expertise, without your contributions, without your sharing of your knowledge, this would not have been successful. It is indeed a gathering of expertise, a gathering of knowledge, African knowledge, on transitional justice, a sharing of experience for the betterment and improvement of transitional justice in our national context. This would not be a success without our coming together, without our knowledge being shared freely amongst each other for replication of what works, what is best practice, what is good practice, what is success, and even sharing of some of our failures so that we do not repeat them. I would like to also thank our interpreters because, again, a meeting of this magnitude that is multilingual will not be possible without us hearing or understanding one another. Lastly, but definitely not least, I would like to thank the technical team made up of FONAREV, CSVR, and the Transitional Justice Unit within the African Union Commission. This would not have been possible without your dedication, your efforts. The gymnastics that happened behind the scenes, we really cannot imagine. They've been in real time attending to logistical challenges. They've been in real time addressing immigration issues, making sure that everyone gets onto the plane and comes as a participant for the Transitional Justice Forum. I would like to thank our partner on the ground, FONAREV, for your dedication, your commitment, the multiple meetings that the technical team has had with you, your willingness as well to contribute to the success of the Transitional Justice Forum. Without your support, we would not have been able to host this successful convening. As we leave Kinshasa, this is a clarion call that I have for all of us. Let us carry with us renewed resolve and a shared commitment to ensure that the principles discussed here are translated into action. Action that will make reparations a lived reality for survivors, communities, and generations to come. Let us carry forward the courage to demand accountability for reparations, the imagination to design transformative reparations, and the solidarity to build a just future across Africa and beyond. Thank you.
Nous remercions le CSVR pour sa participation active à ces assises. À présent, j'invite Madame Nyari pour la déclaration de Kinshasa qui résume les travaux de cette 9e édition du Forum africain sur la justice transitionnelle. Et je précise qu'elle a 5 minutes maximum. On m'informe que Madame Nyari n'est pas prête, alors nous allons poursuivre avec la série de mots de clôture. Et j'invite le représentant d'ICTG pour son mot.
Thank you. If you allow me to associate myself with protocol that has already been observed. Excellencies, distinguished guests, ladies and gentlemen, on behalf of the International Center for Transitional Justice, ICTJ, which is the consortium lead for the Initiative for Transitional Justice in Africa, ITJA, allow me to express our heartfelt gratitude to each and every one of you for your presence and active participation in this 9th African Transitional Justice Forum. I also wish to thank the lead organizers of this important gathering, FONAREV, the Center for Study of Violence and Reconciliation, CSVR, and the Transitional Justice Unit in the Department of Political Affairs, Peace and Security of the African Union for putting together such a stellar event. Our profound appreciation also goes to our gracious hosts, the government of the Democratic Republic of Congo, and to our technical and funding partners, the European Union, ECAS, Impunity Watch, Open Society Foundation, UNDP, the African Transitional Justice Legacy Fund, and to all organizations and individuals whose contributions have made this event possible. I kindly ask you to indulge me so that I could at least give you and share with you a few words about the Initiative for Transitional Justice in Africa and how it relates to the forum. The Initiative for Transitional Justice in Africa is an EU-funded project jointly launched by the African Union and the European Union with the main objective of promoting the popularization of the African Union Transitional Justice Policy and its domestication across African states. The project is implemented by a consortium which comprises of ICTJ, CSVR, and ATJLF. As the consortium, we are proud to have successfully convened 3 editions of the African Transitional Justice Forum under the ITJA banner. In Morocco in 2023, in Mauritius in 2024, and now here in the Democratic Republic of Congo. It is encouraging to note that the forum has maintained its nature and status as a continental gathering, bringing together transitional justice actors from across Africa and beyond to reflect upon, discuss, and assess the state of transitional justice on the continent. The Continental Transitional Justice Forum dovetails with other key interventions under the Initiative for Transitional Justice in Africa, which include the provision of technical assistance through the AU to support transitional justice processes in AU member states, conducting of research concerning contemporary transitional justice issues, and supporting civil society working on transitional justice in Africa through sub-grant awards. To date, in addition to convening 3 continental transitional justice forums, the Initiative for Transitional Justice in Africa has also convened 2 African Union and European Union expert seminars on transitional justice. It has also produced groundbreaking research on contemporary TJ issues in Africa, such as the current inaugural State of Transitional Justice in Africa report, which was launched during this year's forum. We have also deployed experts to support TJ processes in Ethiopia, the Gambia, Lesotho, and to support the development of the IGAD framework on transitional justice. We have also provided sub-grants to 12 civil society organizations working on transitional justice in the Central African Republic, the DRC, Ethiopia, Lesotho, the Gambia, Nigeria, South Sudan, and Zimbabwe. As the curtain falls on this year's forum, we celebrate the convening of this year's edition of the Continental TJ Forum as part of the important milestones achieved under the Initiative for Transitional Justice in Africa. We applaud the African Union's unwavering commitment to advancing inclusive and effective transitional justice processes, and also appreciate the steadfast solidarity and support of the European Union, which is foundational to the Initiative for Transitional Justice in Africa. Yet, as we celebrate these achievements, we must not lose sight of the immense work that still lies ahead. To borrow from the late and great African luminary, Professor Christoph Jens, who spoke of the struggle approach to human rights, and stated that the people's struggle is both the origin and guarantor of human rights. In the same manner, a struggle approach to transitional justice reminds us that normative underpinnings of TJ, its indicative elements and mechanisms, are all born from the struggles of our African people. From landless indigenous communities that demand equal access to opportunities and resources, families searching for the truth concerning the fate and whereabouts of disappeared loved ones, to survivors demanding justice in societies where impunity prevails and perpetrators still roam free, to women, men, and children seeking some form of reparation after losing everything but their very lives. These people's struggles give us meaning and agency to our work. As we part ways, let us not forget about our people's struggles, and that as long as these struggles continue across our continent, our collective responsibility remains. Our work remains as transitional justice advocates to contend with the legacies of inequalities and historical injustices, to address and redress contemporary violations that we face in Africa. Our work must go on. Thank you all. Our lucha continues, the struggle continues.
Après les représentants d'ICTG, j'invite le représentant d'Infinity Watch pour son mot de clôture.
Your Excellency, Monsieur le Ministre des Droits Humains en RDC, distinguished participants, partners and friends, allow me to stand on existing protocols. It has been an honor to share these 3 days of intense, innovative and insightful discussions with all of you here in Kinshasa at the 9th Annual African Transitional Justice Forum. On behalf of Impunity Watch, the organization that I represent, I wish to thank CSVR, the African Union, and all of the organizers of the Transitional Justice Forum, but in particular, the government of the Democratic Republic of Congo, the Ministry of Human Rights, FONAREV, and this beautiful city of Kinshasa, and above all, the many participants whose contributions have made this forum a space of dialogue, reflection, on the critical theme of reparations. Your Excellency, distinguished participants, and dear friends, after such powerful discussions reflecting on the conflict and reflecting on the conflict continuing in the east of the DRC, no one can be in any doubt about the necessity of repairing the past, ensuring redress for historical injustices, and uprooting the systems of abuse that trace their origins to impunity for international crimes, to colonialism, and to the transatlantic slave trade. What has struck my colleagues and I the most from our conversations is the importance for transitional justice to not only address legacies of the past, but also to shape the future. For Impunity Watch and our partners, that future depends on the active and meaningful participation of young people. And as several of the youth who spoke at this forum have so clearly put it, youth are not simply the passive beneficiaries of transitional justice, they are the agents who must define and drive its processes and priorities. Too often, reparations have forgotten young people, have included them simply as a box to be ticked, or have been conceived too narrowly to harness their potential for transforming societies, systems, and the multi-generational traumas passed down through generations. Yet, as many of you have reminded us, without reparations that acknowledge and address historical injustices, there can be no true healing, no trust in institutions, and no sustainable peace. Your Excellency, distinguished participants, what we have seen and indeed felt from the various interventions from the DRC to Namibia, from Kenya to Sierra Leone, is that transitional justice is not abstract, it is lived, it is claimed, and it is demanded by communities across the continent. Those demands for reparations and for restitution must continue being heard in forums like these, but must now be translated into action by all of us working with victims and survivors, and especially by governments on the continent, by governments in Europe and elsewhere, to finally begin delivering justice for historical abuses. Your Excellency, distinguished participants, as we leave Kinshasa, let us all commit to ensuring that the voices of youth are not only heard, but are central to shaping reparations moving forward. And let us ensure that transitional justice continues to be about dignity, about accountability, and about transformation. Thank you very much, and I wish you all a safe journey home.
Au tour suivant, j'invite les représentants du PNUD pour son mot de clôture.
Excellences, Monsieur le ministre, Mesdames et Messieurs les hautes autorités à divers niveaux, Mesdames et Messieurs les représentants de l'Union africaine, distingués invités, chers chercheurs universitaires, acteurs de la société civile, Mesdames et Messieurs, permettez-moi tout d'abord de saluer les riches discussions que vous avez eues pendant les 3 derniers jours et également remercier et féliciter toutes les organisations qui ont été impliquées dans la préparation et la conduite de cet important événement. Le thème qui a été retenu cette année nous interpelle tous parce qu'il nous invite à regarder en face les blessures du passé et du présent, à identifier les mécanismes concrets de réparer les injustices, de restaurer la vérité et de bâtir une paix durable. Il nous rappelle que la justice transitionnelle est un impératif de cohésion sociale qui est en elle-même une condition sine qua non pour le développement durable. Cette justice ne se limite pas à une réponse purement judiciaire, donc stricto sensu. Elle est avant tout une démarche humaine et politique qui vise à reconnaître les souffrances, à restaurer les droits des victimes et à reconstruire le tissu social. Donc rétablir l'agencéité des personnes victimes. Le programme des Nations Unies pour le développement, que je représente ici en RDC, travaille avec plusieurs autres partenaires du système des Nations Unies. Je vois nos collègues du BCNUIDH qui sont ici et d'autres, ainsi qu'avec les gouvernements, pour reconnaître que, en articulant justice, développement et moyens d'existence, on crée les conditions pour l'équité et pour aussi la durabilité des stratégies et des programmes que nous mettons en œuvre. Et la justice transitionnelle, c'est bien sûr une passerelle entre le passé et l'avenir. Elle pense les cicatrices, prévient leur répétition et ouvre surtout la voie à une société fondée sur la dignité. En Afrique, et particulièrement en République démocratique du Congo, vous avez dû regarder un peu les expériences de part et d'autre. Et la situation, elle n'est pas satisfaisante, mais elle n'est pas non plus sombre, parce qu'il y a eu des progrès qui ont été enregistrés ça et là, de bonnes pratiques qu'on peut partager. Il y a les cas de la Sierra Leone que vous connaissez, la Gambie, le Soudan du Sud, la République centrafricaine, ainsi que bien sûr les mécanismes que la RDC a mis en œuvre ici, a mis en place ici pour les réparations. Le simple fait que vous voyez l'implication et l'engagement du FONAREV ici en RDC est l'illustration même du fait que lorsque nous mettons en place les mécanismes pour la réparation, c'est également un appel à l'accompagnement aux victimes. Avec donc ces partenaires des Nations Unies et d'autres, le PNUD accompagne généralement ces efforts à travers 4 priorités, notamment l'appui, premièrement, l'appui institutionnel pour des cadres adaptés et conformes aux normes internationales. Deuxièmement, le soutien aux mécanismes de réparation ciblés et inclusifs. Troisièmement, l'intégration du développement dans le processus de justice. Je disais tout à l'heure que c'est important d'avoir une approche holistique qui permet également de répondre au-delà de la question judiciaire. Et puis, bien sûr, à la fin, la participation citoyenne en mettant, bien sûr, les victimes au cœur des priorités. Nous avons une série d'initiatives avec l'Union africaine au niveau donc, continental. Et il y a par exemple, en partenariat avec la BAD, nous commencerons bientôt un nouveau projet sur la justice transitionnelle au Soudan du Sud, en Gambie, en Guinée-Bissau, dans le cadre de Africa Facility to Support Inclusive Transitions, une initiative phare de l'Union africaine et du PNUD pour accompagner les États membres. Pour nous, et pour finir, je voudrais dire qu'il y a 3 leviers essentiels pour renforcer l'efficacité de la justice transitionnelle. Il y a premièrement l'appropriation nationale, car seules les solutions portées localement sont durables. Quand on parle de l'appropriation nationale, on parle fondamentalement aussi du rôle des gouvernements. Il y a quelqu'un qui disait tout à l'heure que c'est important que les gouvernements soient dans le driver's seat. Et c'est pour ça que quand ces initiatives sont portées par l'Union africaine, nous, ça nous réjouit parce que ça met en défi les gouvernements, les réveille et les met devant leurs responsabilités. Deuxièmement, il y a bien sûr la coopération panafricaine. C'est là où, justement, pour mutualiser les expériences et construire une vision continentale, il est important d'avoir l'Union africaine et les organisations régionales impliquées. Et puis enfin, et on revient toujours dessus, c'est la question de la justice sociale et économique pour s'attaquer aux inégalités structurelles, parce que généralement, il y a toujours un lien entre les violations des droits de l'homme et également les autres conditions qui sont créées par le gouvernement en termes de conditions économiques, conditions sécuritaires et tout le reste. Donc voilà, donc, mesdames et messieurs, les mots que je voudrais partager avec vous en réitérant encore une fois mes remerciements, en félicitant les participants et en disant qu'ensemble, nous serons en mesure de faire de la justice transitionnelle une réalité en Afrique pour le continent, pour les victimes et également toutes les personnes qui sont appelées à apporter leur pierre à l'édification du continent africain. Je vous remercie pour votre attention.
Après les PNUD, j'invite le Bureau conjoint des Nations Unies aux droits de l'homme, à travers son directeur, pour un petit mot.
Monsieur le ministre des Droits humains, chers frères et sœurs, je voudrais d'abord m'excuser pour n'avoir pas été avec vous à l'ouverture de cette importante assise, tout simplement parce qu'au même moment, je devais contribuer à Kolwezi, dans le Lualaba, à un dialogue d'actualité sur les minéraux critiques et les zones économiques spéciales, qui sont les leviers de la vision de faire un bond qualitatif d'une économie d'exportation à celle de la transformation, avec la plus-value en termes d'accroissement des recettes nécessaires pour le développement durable de la RDC, de création d'emplois décents pour les femmes et les jeunes et de contributions substantives à la paix et la stabilisation de ce pays. Vous vous demanderiez très sûrement quel est le lien avec les droits humains et la justice transitionnelle. Une économie et un monde des affaires ancrés sur les droits humains rendent nos sociétés plus stables, plus prévisibles, plus inclusives et forcément plus prospères. Les travaux et les consultations communautaires sur la justice transitionnelle que le BCNUDH continue d'entreprendre dans les communautés, au sein des entreprises minières au Katanga et le Lualaba, confirme l'importance de concilier les impératifs du profit avec la prise en compte du droit au développement des individus et des communautés qui sont impactées par les activités extractives et industrielles. Un moyen, une démarche que seule la justice transitionnelle qui nous réunit ici offre. Je voudrais donc m'associer aux remerciements qui ont été présentés et particulièrement les mots de mon frère représentant du PNUD
ici au nom de la famille des Nations Unies, et simplement ajouter un dernier mot, c'est qu'est-ce qu'on va faire après ici. Les conclusions des présentes assises ici en RDC devraient nous engager dans un pari sur l'avenir, celui de ce que ces recommandations couvriraient une première mise en œuvre ici même, en République démocratique du Congo, dans le contexte actuel et sous le leadership des autorités de la RDC, avec le ministre des Droits humains en premier. Mon bureau est là, prêt à soutenir ces efforts. Et d'ailleurs, et pour preuve, dans les jours qui suivent la tenue de ces assises, mon frère et ministre des Droits humains et moi-même allons co-présider la seconde session de la table ronde de haut niveau sur la justice transitionnelle en RDC et nous allons, comme je viens de le dire, nous approprier des déclarations de Kinshasa sur ce point. Nous attendons aussi l'adoption dans les prochains jours de la future résolution du Conseil des droits de l'homme portant assistance technique à la RDC en matière de lutte contre l'impunité et de justice transitionnelle pour décliner avec vous, y compris avec la Commission de l'Union africaine et les autres partenaires, une série d'activités afin que ces assises ne soient pas une autre rencontre entre intellectuels mais plutôt qui contribuent à la paix, à la sécurité, au développement durable en RDC et au-delà. Le travail continue donc pour nous qui soutenons le gouvernement et le peuple congolais. Et donc, merci à vous qui êtes venus des 4 coins du monde pour partager vos expériences et votre expertise pour renforcer la justice transitionnelle en RDC. Je vous remercie.
La 9e édition du Forum africain sur la justice transitionnelle doit son succès à la Commission de l'Union africaine. Et donc, avec beaucoup d'estime, j'invite son représentant pour son mot de clôture.
Honorable Minister of Human Rights of the Democratic Republic of Congo, Mr. Samuel Mbemba Kabuya, Excellencies, Ambassadors of the African Union member states present, representative of the Diplomatic Corps, Coordinator of CIA VAR, Director of FONAREV, our highly esteemed partners, distinguished experts and participants, ladies and gentlemen. My name is Johnny Kubaje, and I'm speaking on behalf of the management of the African Union. On behalf of the African Union, I wish to express our sincere gratitude to the government and the people of Democratic Republic of Congo for their warm hospitality and generous support in hosting this 9th edition of the African Transitional Justice Forum. I also extend special thanks to FONAREV for its unwavering commitment to the success of this event. Attending countless preparatory meetings, working tirelessly through weekends, and coordinating protocols and logistics arrangements. This dedication not only reflects your desire to contribute to peace and stability on our continent, but it also underscores the importance of your attach to your mandate as a transitional justice mechanism dedicated to providing success to victims of human rights violation in the country. Excellencies, distinguished participants, ladies and gentlemen, over the past 3 days, our discussion have confronted painful truths, shared valuable national and regional experiences, and also reminded us that reparations are not abstract ideas. They are a moral, legal, and political duty owed to victims of atrocities and historical injustices. This forum, therefore, aligns with the African Union theme of the year, Justice for Africa and People of African Descent through Reparation. And it has also reinforced the message that reparations are essential to restoring dignity, rebuilding trust, and breaking cycle of violence. One of the clearest lessons emerging from our deliberation over the past 3 days is that political will is indispensable in pursuing reparation. Equally important, we have seen that undue government interference can undermine the independence of transitional justice institutions and also frustrate the fulfillment of their mandates. A common theme across all sections was that Africa has no shortage of transitional and reparation policies and laws, yet without effective implementation, the wounds of the victims remain unhealed. From South Africa, unfinished reparation business, to Kenya's Toll Victims Fund, to Morocco and Togo's models, the message is consistent, and that is reparation must be anchored in enforceable laws and policies, supported with adequate resources, and delivered through inclusive institutions and processes. Excellencies, distinguished participants, ladies and gentlemen, the example of the DRC FONAREV, funded nationally with additional support from mining companies, shows both courage and commitment, but also reveals the enormous resources gap that persists. We must therefore insist that reparation budgets are not optional to our national government, but integral to national priorities. Distinguished participants, our discussion also highlighted the need to keep women, children, youth, displaced communities, and persons with disability at the center of reparations and transitional justice in Africa. Survivors of sexual violence in DRC, Togo, Sierra Leone, Central African Republic remind us that reparation cannot be limited to financial compensation. They must also include psychosocial support, as some of our participants has alluded to, trauma healing, health care, and economic empowerment. For children, reparation must be integrated into school curricula, and education reforms. For displaced persons, reparation must mean safe resettlement and reintegration. Excellencies, for more than 5 consecutive years, this forum has provided a platform for Africa youth to make their voices heard. They remind us that reparation must speak to their realities. Unemployment, lack of access to education, and exclusion from decision-making. Reparation must therefore be transformative on our continent in Africa, equipping young people with the skills and dignity and leading opportunity they need to prevent the recurrence of violence across the continent. Distinguished participants, equally important, our conversation have reinforced that men and women experience harm differently. Conflict-related sexual violence, reproductive violence, and intergenerational trauma all demand gender-sensitive reparations. Women leadership, therefore, must not be symbolic, but central to community healing and reconstruction. These lessons must continue to guide our member states as African Union, as the primary duty bearer and inspire policymakers, academia, civil society organizations, and all of us who are engaged in this work of reparation and transitional justice on the continent. Distinguished participants, as we close this forum, let us remember that our success is not measured by the organization of events such as this forum, but by our ability to implement the important recommendations that emanate from them. In that spirit, I wish to once again, on behalf of the African Union, thank our principal partners, the Center for the Study of Violence and Reconciliation, CSVR, for its steadfastness in co-organizing this event with the African Union over the past years. I also want to acknowledge, on behalf of the African Union, the contribution of other consortium members implementing the Initiative for Transitional Justice in Africa, a project of the African Union and European Union, the International Center for Transitional Justice, and the African Union Transitional Justice Legacy Fund. We say a big thank you for supporting implementation of African Union Transitional Justice. Our gratitude also goes to the European Union, the European Center for Electoral Support, ECES, the Open Society Foundation, the United Nations Development Program, and also Impunity Watch, and all other partners for their continued support and tireless effort in ensuring the success of the forums over the years. In conclusion, as we return to our respective destination, let us carry with us the reminder that peace and stability on our continent, and by implication in the wider world, remain a shared responsibility, one in which every one of us have a role to play. I wish each and every one of us safe travel and journey mercy back to our different destinations. I thank you.
Encore une fois, merci. Merci à la Commission de l'Union africaine pour cette 9e édition du Forum africain sur la justice transitionnelle. D'affilée, j'invite le président de la Commission nationale des droits de l'homme en République démocratique du Congo pour son petit mot.
Excellences, Monsieur le ministre des Droits humains, Excellences, Mesdames et Messieurs, distingués invités, c'est avec une profonde reconnaissance que je prends la parole à l'occasion de la clôture de la 9e édition du Forum africain sur la justice transitionnelle, organisé pour la première fois en République démocratique du Congo par le ministère des Droits humains. La tenue de ces grands rendez-vous à Kinshasa constitue un moment historique pour notre pays et pour l'Afrique. Le thème choisi, justice pour les Africains et les personnes d'ascendance africaine à travers les réparations, met en lumière un enjeu majeur, celui de placer les victimes au centre des mécanismes de vérité, de justice et de réparation. En République démocratique du Congo, les blessures encore vives des conflits rappellent combien la quête de justice et de dignité est essentielle pour les femmes, les enfants, les jeunes et les communautés affectées par les violences. En tant qu'institution d'appui à la démocratie, la Commission nationale des droits de l'homme salue cette initiative et réaffirme son engagement à poursuivre sa mission de documentation des violations de droits humains, d'accompagnement des victimes et de plaidoyer en faveur de leur réparation. Car au-delà des concepts, la justice transitionnelle doit être une réalité vécue par celles et ceux qui ont souffert et qui continuent à souffrir. La CNDH salue également l'engagement du président de la République, son Excellence Félix-Antoine Tshisekedi Tshilombo, qui a fait de la promotion et de la protection des droits de l'homme un axe prioritaire de son mandat. C'est dans cette vision que nous devons ensemble renforcer nos actions pour que la justice transitionnelle contribue réellement à la cohésion nationale et au processus du retour de la paix durable en République démocratique du Congo. Je félicite donc le ministère des Droits humains et les partenaires techniques et financiers pour l'organisation réussie de ce forum. Les recommandations ici de nos échanges ouvrent de nouvelles perspectives pour la République démocratique du Congo et pour l'Afrique entière. Que ce forum nous inspire à poursuivre avec détermination la lutte contre l'impunité et à bâtir une société fondée sur la justice, la solidarité et le respect de la dignité humaine. Je vous remercie.
Chers participants, acteurs de la justice transitionnelle en Afrique et ailleurs, il n'y aurait pas eu cette 9e édition du Forum africain sur la justice transitionnelle à Kinshasa, en République démocratique du Congo, sans la volonté et l'engagement du gouvernement congolais. Et cela à travers son ministre des Droits humains, à la personne de son Excellence, M. Samuel Bemba Kabouya, que j'invite pour son mot de clôture. Excellence, Monsieur le ministre.
Excellences, honorables députés, Mesdames et Messieurs, distingués participants à la 9e édition du Forum africain sur la justice transitionnelle, dont le thème était « Justice pour les Africains et les personnes d'ascendance africaine à travers les réparations ». Je vous dis merci. Merci d'avoir pris part à ces travaux ô combien importants. Aujourd'hui s'achèvent nos travaux et ainsi je vous remercie et vous félicite à la fois pour l'assiduité dont vous avez fait part durant cette édition, mais en particulier pour la pertinence de vos apports. Mesdames et messieurs, l'Afrique a trop souvent été vue comme une victime de l'histoire. Elle peut aujourd'hui en devenir l'acteur résilient. Nous devons, en tant qu'Africains, dépasser les fragmentations de nos efforts, créer des instruments financiers africains de soutien aux victimes, favoriser la coopération sud-sud sur les mécanismes de justice réparatrice, former une nouvelle génération d'experts africains en justice transitionnelle. Mesdames et messieurs, réparer, ce n'est pas une faveur, c'est un droit. Réparer, ce n'est pas effacer le passé, c'est lui donner un sens. Réparer, ce n'est pas affaiblir l'État, c'est le renforcer en dignité, en légitimité et en humanité. La République démocratique du Congo, à travers son gouvernement, qui travaille sous la vision de son Excellence, Monsieur le Président de la République, chef de l'État, Félix-Antoine Tshisekedi Tshilombo, laquelle vision est matérialisée par Madame Judith Suminwa Tuluka, Première ministre et chef du gouvernement, confirme sa détermination et son engagement à faire de ce pays un laboratoire de justice transitionnelle en Afrique. Et nous ne serons pas seuls. Nous avons avec nous les victimes, les communautés, les partenaires, les juristes, les survivants et surtout l'histoire elle-même. Ce forum qui se clôture aujourd'hui ne doit pas être une fin. Il doit être un tournant décisif pour l'Afrique. Nous n'avons plus le droit d'avancer à pas lents quand la douleur, elle, court dans les veines de nos peuples. Je formule ces quelques vœux qui doivent faire en sorte que l'Afrique devienne un continent de justice réparatrice. 1. Reconnaître officiellement les victimes dans chaque pays, c'est-à-dire par des lois, des cérémonies nationales et l'institutionnalisation de leur mémoire, comme nous l'avons fait ici chez nous à travers les sites que vous avez visités, le site dit Génocoste. 2. Créer un cadre juridique africain sur la justice transitionnelle, aligné avec la politique de l'Union africaine pour harmoniser les réponses aux atrocités. 3. Mettre en place un fonds africain de solidarité pour les réparations, lequel fonds peut être financé par les États membres, la diaspora africaine et les partenaires. 4. Faire du mois d'octobre mois africain des réparations, avec des commémorations, des débats publics, des engagements politiques concrets. 5. Protéger les victimes, les témoins, les journalistes, les défenseurs de droits humains avec des mécanismes nationaux appuyés par des institutions régionales. 6. Adopter une charte de reconnaissance des enfants nés du viol pour qu'aucun d'entre eux ne soit traité comme une erreur, un oubli, un fardeau. 7. Et enfin, former une génération africaine d'experts en justice transitionnelle avec le centre de recherche des universités partenaires et des bourses africains. Mesdames et messieurs, Les victimes n'attendent plus des promesses. Elles attendent des réparations, une reconnaissance, une place dans l'histoire. L'Afrique ne guérira pas tant que ses blessures seront niées. Elle ne se relèvera pas tant que les femmes violées se cachent. Elle ne brillera pas tant que ses enfants, nés du chaos, sont traités comme des ombres. C'est ici, à Kinshasa, que nous avons choisi de rompre avec le silence. C'est ici que nous avons commencé à dire aux victimes, nous avons entendu, nous allons réparer. Et si demain, un enfant demandait ce que l'Afrique a fait pour les siens, alors que ce forum soit la réponse. Qu'ils se souviennent que des dirigeants, des survivants, des juristes, des ministres se sont levés pour dire non. Mesdames et messieurs, il me reste finalement à formuler le vœu suivant. En rentrant chez vous, chez nous, parce que vous êtes africains, les Congolais sont africains. Chers partenaires, en rentrant chez vous, chez vos partenaires, n'oubliez pas ce qui se passe en RDC. Ce pays est en train de connaître le drame que le monde n'ait jamais connu. C'est qu'il y a ici déjà plus de 10 millions de morts, 10 millions de victimes survivantes, donc 20 millions de morts impactés par la situation de l'Est du pays. Et si notre population est aujourd'hui estimée à un peu plus de 100 millions, ça signifie que 20% de la population congolaise est impactée directement par les affres d'un crime ignoré, d'un génocide. Nous n'avons pas de honte ni de peur à nommer l'auteur. C'est le Rwanda de Paul Kagame. Ne nous oubliez pas en partant, parce que 20% de la population est touchée, mais aussi le reste de notre population est impacté par la situation de l'Est de ce pays. Voilà pourquoi ce pays, historiquement, potentiellement riche, plus que tout État, tout pays du monde, son peuple vit encore dans la misère. Parce qu'il faut soutenir l'effort de guerre. Si vous parlez pour la RDC, si vous soutenez la reconnaissance du génocide de la RDC, vous aurez agi en suivant la voie des valeurs, la voie de la dignité. Mesdames et messieurs, je vous remercie.
Merci. Merci à son Excellence Samuel Bemba Kabouya, ministre des Droits humains, pour son engagement, pour sa détermination à rendre efficace et effective la justice transitionnelle en République démocratique du Congo. Merci, Excellence. J'invite à présent l'assistance à se tenir debout pour entonner l'hymne national de la République démocratique du Congo et boucler ainsi la 9e édition du Forum africain sur la justice transitionnelle. Je vous remercie. Vous pouvez vous installer. Nous allons à présent passer à la photo de famille. Le protocole, s'il vous plaît. Votre attention, s'il vous plaît, s'il vous plaît. Dans le même élan, on va entonner l'hymne national de l'Union africaine. Oui. Excellences, Monsieur le ministre, et les officiels, s'il vous plaît, pour la photo de famille. Nous vous invitons au podium.